Bombay High Court bar at the age of 25 and soon enough earned a respectable name, followed by a lucrative practice, a matter of fulfillment for a lawyer with no pedigree of venerable genealogy to support him. While practice demanded his time, his passion for teaching drove him to be a part-time teacher in the Government Law College, Bombay. It's reported that his service both as assistant government pleader and as public prosecutor in the High Court were of equal excellence and competence and carried the worthy dimensions of a passionate teacher. We could find the imprints of such excellence in the reflective insights that he could share in the large number of judgments penned by him. Having become a judge at the High Court at the age of 43, he served the Bombay High Court for a good 17 years with distinction. In January 1994, appointed as the Chief Justice of Punjab and Haryana High Court and elevated to the Supreme Court in March 1996, Justice Kurdukar served his court with distinction till his retirement in January 2000, a 3-year tenure being a short time to be spent on the bench. As I said earlier, Kurdukar's engagement in the application of rarest of rare cases principle maintained a deductible balance. For instance, in Sriram versus so-and-so, a bench comprising just Kurdukar and K.T. Thomas upheld death sentence for Shivaram and Sriram, only 2 of the 24 accused in the premeditated massacre of 11 family members. But conversely, in another case, Justice J.T. Dhanavati and Kurdukar commuted the death sentence of the appellant convicted for a contract murder and guided by the absence of broader societal threat or exceptional depravity beyond a single victim homicide. In all those matters, which involved reviews under Section 302 and 376 IPC, he was insistent in emphasizing empirical evidence of intent and perceived impact and did not press presumptive deterrence beyond a degree. Following his retirement, services Justice Kurdukar were sought after as a sole arbitrator in wide-ranging civil and commercial as well as in family disputes. He discharges service in several statutory oversight roles, having been appointed by the Company Law Board. Though the one-man commission of inquiry headed by him to investigate the Dobol power project engagements with the Enron, following unseemly controversies in the fitness of things, Justice Kurdukar declined his engagement in the commission. This is certainly a hallmark of ethics and integrity and the importance of maintaining the high standards of former judge of this court. Needless to say that this was in keeping with the general tradition of former judges who were called upon to head commissions of inquiry. The S.B. Kurdukar's judicial philosophy emphasized adherence to statutory text, judicial restraint in reviewing executive actions, and a measured application of discretion in sentencing, particularly in criminal and constitutional contexts. His approach reflected a commitment to the rule of law as a cornerstone of equality and fairness, cautioning against arbitrary state or judicial overreach. In Modi Simmons, the bench, including Kurdukar, observed that any breach of the rule of law negated the constitutional guarantees of equality under Article 14, underscoring the need for consistent and principled governance. In administrative and constitutional matters, Justice Kurdukar advocated restraint to preserve separation of powers. This stands aligned with a philosophy prioritizing legal certainty over expansive activism. Regarding criminal jurisprudence, especially sentencing under stringent laws, Justice Kurdukar's contributions highlighted a philosophy balancing retribution with proportionality. We today join the members of the family of Justice Kurdukar in their bereavement and pray that his soul rests in heavenly peace.
Honorable the Chief Justice of India, Justice Suryakant, Honorable Judges of this Court, Learned Attorney General for India, Learned Solicitor General for India, Law Officers of the Government of India, respected family members of late Justice S.P. Kurdukar, members of the Executive Committee of the Supreme Court Bar Association, Shri Vipin Nair, President SORA, members of the Executive Committee of SCORA, members of the Bar, ladies and gentlemen. The permanence of our judicial system is not merely found in the letter of law, but in the warmth and wisdom of the individuals who breathe life into it. We gather here today with heavy hearts to pay tribute to a man whose journey from the rugged terrains of Marathawada to the highest bench of our land serves as a beacon of perseverance and judicial integrity. Late Justice S.P. Kurdukar was a custodian of fairness and a paragon of humility. On behalf of the bar, I extend particularly a warm and respectful welcome to the family of Justice Kurdukar. We are honored by the presence of those who have joined us physically today: his daughter, Sujata Kurdukar, his son-in-law, Neeraj Kumar, his daughter-in-law, Tejal Subodh Kurdukar, and his grandchildren, Vedant and Lavanya. We also extend our deepest respects and warm welcome to those joining the reference to a virtual mode: his wife, Mrs. Mandakini Kurdukar, and his daughter, Mrs. Sunita Kurdukar Kumar. Your family's enduring commitment to the legal profession is a testament of the profound influence of Justice Kurdukar's values. Justice Sudhakar Pandit Rao Kurdukar was born on 16 January 1935 in a small town of Amba Jugai, Beed district, Maharashtra. Having obtained his Bachelor of Art and Bachelor of Law from Marathwada University, he chose to build up the legacy of his father and his grandfather, who were seasoned lawyers of their time. Yet, rather than resting on their laurels, he chose the path of independence. Upon enrolling on 31st of August 61 at the Bombay Bar Council, he ventured into the challenging legal corridors of the Honorable High Court of Bombay as the first man in his family to practice in the city, a move that demanded immense courage, sacrifice, and indomitable spirit. The early years of his career were shaped by real struggle. At a time when the bar was extremely competitive, he stood out because of his hard work and his unwavering commitment to ethics, honesty, and sincerity. His practice covered a wide range of work, civil and criminal matters on the appellate side as well as on writ petitions. Whether he was teaching at the new law college as a part-time professor or representing the state as assistant government pleader, and later as public prosecutor, he carried out the same sense of responsibility and integrity into every role. His influence as a mentor was equally enduring. Many distinguished legal minds, including late Justice A.B. Naik, began their career in his chamber. Justice Naik, who joined him in 1970 and worked alongside him for a decade, often credited his own judicial discipline and depth of learning to the rigorous training he received under Justice Kurdukar's guidance. His elevation to the Bombay High Court in 78 and his subsequent appointed as Chief Justice of the Punjab and Haryana High Court and his tenure as acting governor of Punjab in 1996 highlighted his versatility as a constitutional statesman. When he ascended to this honorable court in 96, he brought with him a balanced judicial philosophy. I had the privilege of appearing before him and witnessing firsthand his tenure marked by a commitment to merit and institutional integrity. In Osmania University, he underscored that courts should be slow to interfere with objective academic selections made by experts. Similarly, in Ramchandran versus Govind Ballabh, he established administrative law by ruling that seniority rules must be applied consistently to prevent arbitrariness in service matters. Justice Kurdukar's impact on criminal jurisprudence was perhaps his most enduring legacy. He possessed the uncanny ability to sift through testimonial potency of evidence. In State of Punjab versus Gurmeet Singh, he championed the dignity of the prosecutrix, ensuring that the legal process did not re-traumatize the victims of sexual assault. His meticulous eye for detail saved many from the miscarriage of justice he often warned against, notably in Suraj Dev Yadav versus State of Bihar, where he emphasized that quality of evidence must always outweigh the quantity of witnesses. Whether dealing with the nuances of private defense in Pandapa Hanupa Hanamar versus State of Karnataka, or testing the credibility of eyewitness in Ballu versus State of Haryana, he remained a sentinel of truth. In the realm of public law and governance, he balanced state interest with individual rights. In Gopi Aqua Farms versus Union of India, he dealt with the critical balance between aquaculture development and environmental preservation. In the sensitive arena of religious management, his judgment in Sri Jagannath Puri Management Committee versus Chintamani Kuntia clarified the boundaries of secular interference in religious administration. From protecting civil rights in Union of India versus Praveen Gupta to deciding intricate property and tenancy disputes, Justice Purdukar's pen was as versatile as it was wise. His clarity in commercial and procedural law was equally definitive. In Modi Cements versus Kuchil Kumar Nandi, he strengthened the Negotiable Instruments Act by clarifying that stop payment instructions does not absolve one of liability, thereby protecting the sanctity of the commercial paper. In CBI versus VC Shukla, he addressed the high-profile Jain Hawala case, setting rigorous standards of admissibility of entries in Book of Accounts. Even after laying down his robes on 15th of January 2000, his dedication remained undimmed. As a sought-after arbitrator and a trusted administrator, he notably headed the one-man commission of inquiry into the Dabhol Power project and served institutions like Leela Havati Hospital. In a legal career spanning over 55 years, he proved that a legal mind of his caliber never truly retires. Justice Kurdukar was a man of immense stature who never lost his touch with his roots. He conducted himself with a dignity befitting his high office, yet possessed a humility that endeared him to his staff and extended family alike. His warmth, honesty, and most of all, his loving presence will be missed forever by the legal fraternity, his colleagues, his friends, and most dearly by his family. In the passing of Justice Kurdukar on 21st of March 26, we have lost a titan, but his contribution to Indian jurisprudence will continue to guide us for generations to come. May his soul rest in eternal peace, and may his memory continue to inspire generations to come.
May I have your lordship's permission to conclude the proceedings?
The court will sit for normal work at 11:15.
Positive. Same दूसरे से लगा दो बहुत अच्छा लगा ये हम सही कर देंगे प्राइवेट से भी प्राइवेट जो चला देगा जो देगा वो लोकल देगा
Yeah.
Lord, first, Lord, Sabarimala judgment proceeds on an assumption that men are superior.
I would like to mention a matter, my lords. The petitioner and her minor daughter has been thrown out of her house, my lords. Even when the mediation was
And women on a lower pedestal. At page 30 of my written submissions, volume 2, at PDF 36, I'm not reading it, your lordships need not open. I have given instances of temples where men are not allowed. Because it's a Devi Bhagavati temple, there are some faith and belief. There are temples, I have mentioned the details, where male priests are under a mandate, religious mandate, to wash the feet of female devotees. There are temples like Pushkar temple, only Brahma temple in the country, where married men are not allowed. There are certain temples where there is one temple in Kerala where the system is that men will go dressed as women. And I read in detail. They go to beauty parlors and their family, the lady family members help them dress, wearing sari and other things, and they go, and only males go. So, it is not male-centric or female-centric religious beliefs. In this particular incident, it happened to be a woman-centric. Second, there was a question, regarding Article 25, 26 and their interplay. Day before, I have substantially argued. I thought yesterday night, when I began yesterday, I said that I'll take that last because otherwise I'll not be able to finish other questions. And I couldn't get time, for that. I'm not, re-arguing. Substantially, I have answered. Rest is in my written submission.
That's it.
But it may not be felt that I skirted or I ducked those questions.
No.
That's the only thing.
You have noticed that
And,
outside.
yes, my lord. And, my lord, last thing, my lord, I have confined my submissions on 25, 26 for so far as the questions frame. There are other issues like control of government, government controlling temples. There are other issues, etc. Lord, that is not the issue arising. So I have not, my lord, addressed
Before us, there are only those 7 questions which have been
so
referred.
my argument is confined, my lord. It may not be
Yes, we are
understood.
also confining only to respond to those.
Yes, my lord.
Yes, Mr. Nataraj, for the union. Is there any written submission given?
Yes, my written submissions are at page volume 1.7. Starts from page number 220.
Volume?
Volume 1.7.
1.7. Page?
Union. 1.7 starts from page 220.
220.
220. The hard copies also I can. The hard copies. You to the board. Other side also.
Thank you.
Yes.
Hard copy of this submission.
Please.
Actually, starting from 222.
Yes, I'm sorry. 220. Religious rights under the Constitution are well knitted, protected, regulated under a scheme of Article 25 and 26. We have a three-tier mechanism to protect, to connect, and to regulate religious rights under the Constitution. First part of 25(1), that guarantees an individual right. Second part of 25(2), that is a regulatory mechanism. And when it comes to 26, that relates to institutional right. So 25(1) and 26 are well interconnected, and 26 is embedded on 25, and vice versa. When it is 26 is to be enforced, basically it relates to 25(1). So 25 and 26 are well connected, interconnected two mechanisms, giving right to an individual under 25(1), and when it comes to an institutional right, it is guaranteed under 26. But however, when it comes to a regulatory mechanism, it is 25(2), which applies to both. This is the scheme of 25(1), 25(2), and 26. Therefore, there are three-tier mechanism is provided under the Constitution to provide, to regulate the religious rights under the Constitution. It's a well-balanced right which is provided under the Constitution. That is the first part of it. Now, kindly take my written note where I pointed out the broad submissions. Starting from para 2, I pointed out about 8 salient aspects of the rights under Article 25 and 26 are concerned. First one, scheme under 25 and 26 constitutes a three-tier mechanism. 25(1), 25(2), and 26. Right under 25 is twofold. That is the religious freedom of and state's power to regulate, and Article 25(2) further consists of two independent parts. That's a 25 is concerned. That's a twofold initially. First one is individual right, then 25(2) for the regulating. Then Article 25 and 26 must be harmonized. Neither provision is subordinate to the other. That's the third one. Fourth one, denomination must be understood in the Indian context. That I will elaborate when I come to with reference to the debates also. It has to be understood how the denomination has to be understood or construed while interpreting the provision. Then public morality is the governing standard and not a constitutional morality as interpreted earlier. So public morality is the governing standard. Governing standard is the public morality, not the constitutional morality as held in other previous cases. That is the next one. Next one is the determination of essential religious practices unsustainable in the Indian religious landscape. When we consider the cases of Indian religious landscape where there is a diversity or plurality, we can't apply the principles of essential religious practice. Then the religious practice are to be internally assessed. External examination is impermissible. I'm saying the judicial review of whether it is an essential practice or to what extent in the judicial matters we can go into has a very limited scope. The last one, the deity's right is an integral part of the devotee's right and protected under Article 25 and 26 of the Constitution. Deity's right, that is an integral part of the devotee's right, and it's vice versa. If a devotee has a right, that relates to the deity. If the deity has a right, that relates to the devotee. So 26 and 25(1) are necessary to be connected. We can't separate. If you have a faith, then you have right under 26. If you have no faith, if you are a non-believer, you have no right under Article 26. So necessarily 26 will have to be connected to 25(1). These are the broad points which I would like to elaborate. Now kindly turn to the second page. Scope and contents of Article 25(1), without reading in detail, what I have said is, Article 25(1) includes not merely internal belief, but also the external manifestation of religion through practice and propagation. There are two folds. One is the internal faith. I may have certain internal faith that is completely protected. Not only that, even the manifestation of my faith, that is also equally protected under Article 25(1). Then kindly come down to 25(2), that is as an independent enabling mechanism. Article 25(2) creates a distinct field of legislative competence for the state. This provision is not a mere restriction on 25(1), but an independent constitutional authorization that allows the state to regulate secular activities associated with the religion to achieve broader societal objectives and intend to transform the society. The object of 25(2) is to regulate or as an independent enabling mechanism given under the Constitution to the state. That is to eliminate social evils and bring about inclusive reforms. That is the second stage of it. However, when we come to 25(2) B is concerned, there are two independent components. The first one is enabling the state to make law. The second one is throwing open the Hindu religious institutions to all sections of the Hindu. First part and second part both are independent. Disjunctively it is expressed. 25(2)B are disjunctively expressed. Kindly see, providing for social welfare and reform, or the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. So first part is providing for social welfare and reform. That's the first part of it. And the second one is for throwing open. So disjunctively that is expressed. So there are two parts, both are independent. Then kindly go to Article 26 is the next provision which I dealt with in the next under the heading C.
So keep in mind,
Please.
Article 25(2) itself is in two parts.
Two parts.
The first part is nothing in this article shall affect the operation of any existing law.
Correct.
Second part is or
To make law.
prevent the state from making any law. The latter part is A and B.
Yes.
That is an enabling provision to the state. But what is the meaning of nothing in this article shall affect the operation of any existing law?
Existing law will have to be
Pre-constitutional.
pre-constitutional laws. Article 366 or whatever the laws.
Component of that existing law.
The
Include a custom and usage.
custom and usages, if not inconsistent with the part 3, they have to be protected. The test would be whether article part 3 would be applicable or not. We can't argue or we can't read 25 and 26 divorce part 3. Both 25 and 26 are subject to part 3. They are interconnected. Therefore, I pointed out 26 can't exist without 25(1) and 25 has to be related to 26. When they are related each other, then necessarily part 3 has to apply. Notwithstanding, there is no express provision under 26 to say that it is subject to part 3. But nevertheless, 25 provides it is connected to 26. 25 was individual. When it comes to 26, it relates to the institution. So 25(1) and 26 have to be read together and subject to part 3.
Then are you not putting a fetter on Article 26 in the form of part 3?
Part 3, yes.
It is conspicuous by its absence.
Yes. But it can't, yes.
Conspicuous. It is part 3 is conspicuous by
in the existence 25(1). Individual. Without is formed on the basis of like faith of individuals.
Consciousness, collective faith will come.
Absolutely.
Right to faith can be given effect to by collective association.
Collective association.
With the form and the form of
Absolutely.
Mr.
I'm great.
Nataraj, Mr. Nataraj,
Please.
to summarize what you're saying
Yes.
is 26(1)(b
Yes.
is a subset of 25(1).
It's not subset, but it can be an offshoot of an individual right collectively.
Why I say subset
yes.
is the word maintain,
Yes.
religious affairs.
Yes.
So it only relates to maintaining religious affairs.
Yes.
Whereas 25(1) has much expansive expressions.
Correct.
Profess, practice,
Correct.
and
Correct.
propagate.
Yes.
So profess, practice, propagates is the bigger set,
Bigger, sir.
of which the subset is maintenance.
Yes.
And maintenance naturally relates to organization, which yesterday I indicated to the
Yes,
Solicitor General
Yes.
that it is not the devotee,
Yes.
but the management
Yes.
whose rights are envisaged in 26.
Yes.
And therefore, you say that these to be harmoniously constructed.
Harmoniously construed.
So
25 and 26 will have to be harmoniously construed, and
thereby 26(1)(b)
Yes.
is also subject to the social reform legislations of 25(2).
yes, 25, it has.
But the next question is,
Hmm.
you are saying, as you rightly say, that
Yes.
if the harmony is to exist, it's
Yes.
to exist on all part 3.
All parts. All.
How do you compatibly interpret 26(1)(b) with Article 15 or Article 14? That is, definitely you have addressed that.
Because that we have to read only by reading under 25(1) only, that can be achieved.
Argue on in your own way.
Yes.
Just
Yes,
indicated. Please
I
address that in the-
understood. Because 25 and 26 are two faces of same coin of religious right. This one is relating to an individual right, the other one relating to institutional right to form an association or to express through an as a denomination. So it will be two faces of same coin of religious right of the either citizens or collective.
26 is not of citizen. 26 is of the
Collective.
unit, or
No.
rather the organization.
Absolutely. That's
25 is of the individual.
individuals. That's what I,
These are
25.
distinctive
Yes.
things.
Without individual.
25 therefore
Hmm.
is a larger sweep of practice, belief, practice, profess.
Yes.
26 is of a narrow spectrum, manage. See the word that they're definitely the constitution makers had
It is just
intention.
like, it is just like the concept of an association or a trade union.
Yes.
You represent the collective group of the laborers, but which means you are entitled to protect the rights of the labor vis-a-vis your own individual rights with respect to management or managing the affairs of the society.
Absolutely.
The property and
Absolutely.
other things.
Absolutely. Absolutely.
Yes.
That is Simon.
25 is individual,
Yes.
26 is a group of individuals.
Group of individuals.
Who have been nomenclatured in a
Nomen-
particular
yes.
form.
So therefore,
Got the.
Group of individuals having the same conscience
Yes.
with regard to a philosophy of religion can come together as a religious denomination. And then that religious denomination as a community or that group will have some rights.
rights. It can be faith, can be different. It can be varied faiths. This one individuals can have.
It's individual.
Yes. 25(1) it is especially for individuals.
He need not be part of a denomination.
Correct.
But if he is a part of a denomination, then the denomination gets that right.
Strike right under 26. Yes, this is the scheme of the constitution under 25 and 26. But both can be regulated by invoking 25(2).
Yes.
So this is a fine mechanism provided under 25(1), 25(2), and 26.
The overriding expression in 25(2),
Yes.
that nothing in this article shall,
Yes.
that kind of a non-obstante clause
Yes.
is referable to Article 13.
Yes.
When they talk of the operation of any existing law,
Yes.
means a law which is protected under Article 13. And that include the customs, that include the usage having force of law. That is what.
Because, I mean, the expression existing law is given in subarticle clause 10 of Article 366.
366.
How do you reconcile that existing law with Article 13 law we have to see?
We have to read the
Ah.
both the provisions harmoniously when it comes to religious right to say that which is not inconsistent with the part 3. That is the only solution. So long as it is consistent with the part 3, whether it is a pre-existing or the future, the law, they have to succumb to part 3, regulated by part 3 of the Constitution.
Mr. Natraj, you just referred to, if I've understood you correctly, that
Please.
Article 25(1) includes not merely internal belief,
Yes.
but also the external manifestation of religion through practice and propagation. Are you putting it in a very plain term that whatever is your internal belief, religious belief, the external manifestation also is protected?
Yes.
How can it be?
It,
Till the time internally, yes,
Yes.
blanket, it is yours.
yes.
The moment your external manifestation has affected the right of some other section, how can it be protected?
No,
Then it has to be tested.
Subject to part 3.
Your internal may be very, okay, you are absolutely
Yes,
protected.
yes.
But then the moment you say that my internal will also be enforced externally, and that has some relationship with the rights of others in the society generally,
Yes.
then the other part 3,
Part 3.
14, 16.
Part 3 immediately steps in.
You are right. Then
Yes.
you cannot say that whatever internal is, you carry it externally also, and then that will
No, the
protect it.
entire article is subject.
To with any other right.
Yes.
The article is
So,
subject.
number 1, article itself provides, it is subject to. When we come to 25,
Yes, you develop your submission, let's.
Please,
we will
yes.
discuss.
then article, kindly turn to the next page, column C. I pointed out, or I said it is article 26 is not absolute. Again, it is subject to part 3 of the Constitution. That is the next argument or the line which I have taken. The third one is religious denomination or any section thereof must be interpreted in the Indian context. Now, the right guaranteed under Article 26, that is to religious denomination or any section thereof. The construction would be, kindly turn to para 11. Article 26 of the Constitution of India, which guarantees the right to manage religious affairs, find its origin in Article 44 of Irish Constitution 1937, which itself was based on Article 114 of the Polish Constitution 1921. However, such borrowing must not be used as a rigid transplantation of meaning. The origin or the idea of Article 26 may be foreign, but its interpretation must necessarily be indigenous, keeping in mind the Indic religions and the social, cultural, and religious demography of India. In any of the above stated position, the expression religious denomination or any section thereof must be given a purposive interpretation considering India's unique religious landscape. So while interpreting the denomination or section thereof, we can't keep in mind what prevailed in Ireland, or when they brought in the idea of the Irish Constitution or the Polish Constitution. We have to keep in mind how they thought of to introduce the denomination into Indian system. That will have to become understood. Kindly, for that purpose, kindly go to how it was understood and how it was debated. Actually, how it is understood in original Hindi language, how it was said. It is said as, kindly turn to para 12, Article 394A, 3 of the Constitution. Kindly turn to Article 394A. Article 394A, 3. The translation of this Constitution and of every amendment thereof published under this article shall be deemed to be, for all purposes, the authoritative text thereof in Hindi language. So denomination, no doubt it is as an English word that is employed in the Constitution, but when it comes to Indian landscape, it is called Sampradaya. What is protected under Article 26 is nothing but Sampradaya. It's a Dharmic Sampradaya. In Hindi, it is said it is Sampradaya. If you take the original Constitution also, Article 26 refers to Sampradaya.
Not the actually denomination which is protected. It is matters of religion.
Religion.
That is sampradaya.
Sampradaya.
That is protected.
Protected. For 26, the word or the expression of denomination will have to be understood as a Sampradaya.
धार्मिक संप्रदाय या उसके किसी अनुभाग.
Yes.
Means a section.
Yes. Now kindly turn to para 13 of my note. The meaning of the term Sampradaya is significantly broader and culturally rooted than English word denomination. Sampradaya denotes a religious tradition that is transmitted through teachings, practices, customs, and lineage, and does not necessarily require formal institutional structure. Sampradayas will not or necessarily will have any formal institutional structure. As such, any group of persons sharing a common religious tradition in any form could be a sampradaya or denomination. The recognition of group of individuals or institution as sampradaya or denomination would depend on the standard of classification and the fact in a particular case. So it is ultimately standard of classification. The classification not referable to the denomination relating to a particular religion and the section thereof. It is a form of the collective group of the collective expression of a group or the collective right of the group and having a common belief. That is the test. In para 14, further, the inclusion of the words any section thereof clearly indicates that the Constitution contemplates not only well-defined denomination, but also smaller segments within the broader religious traditions. This includes, but is not limited to, practices that may be unique to a particular temple, sect, or institutional tradition. Thus, in the intent of using Dharmic Sampradaya reflects a wide and inclusive protection rather than a narrow and exclusionary, which encompasses a wide range of beliefs, practices, and traditions. A restrictive interpretation of the said phrase would defeat the constitutional objective of protecting religious autonomy across the spectrum of India's religious life and lead to a situation where the protection under Article.
So you are saying there's no need for a review on the, there's no need to do this. Simply you have to take the existence of a group of believers.
That's right. That's right.
It should be given that much of flexibility.
That's right. That's right.
Please don't go on.
It is very flexible. It is very flexible.
So therefore, that flexibility you give.
Yes, it should be very flexible. A group of few people, they may follow a particular sampradaya, and if that is according to their belief, collective belief, that has to be protected. It is with reference to Article 25(1). So collectively we have right under 25(1), and it transfers into the denomination or sampradaya to be followed from time immemorial, and that is protected under 26. That is a protection.
Can the sampradaya change its belief?
It can. It is no rigid structure at all for sampradayas. It is a matter of faith.
But sampradaya is something which has come time immemorial.
From time immemorial,
It is something of permanence.
But
it can be done fresh also, no problem.
yes,
You can create a new ideas, new belief. That's what it
May
is.
introduce many things, of course.
I would
But the
rephrase
base
the
or
question.
remains.
When the sampradaya changes its belief, does it become a new sampradaya or it is the same sampradaya?
sampradaya, it has no definite meaning as such. If you are able to, under the facts of a particular situation, if you are able to point out or prove in a particular given case, yes, this is the sampradaya, we are collectively following it. And that has to be protected.
Let us say a sampradaya
Yes.
feels one of the common beliefs is one of vegetarianism.
Yeah.
And thereafter decides, a section of it decides that that is not enough.
Yeah.
There should be fasting. And that becomes a belief. Now, can that sampradaya, after change of belief, become a new sampradaya?
Yeah. That's how in different religions,
According to you, that will become a new sampradaya.
new sampradaya.
That is
Different,
what I am
yes, different sampradayas keep on
That
coming.
is what I am asking you.
Yeah.
That a sampradaya having, because if you see religion, although we are not seeing a specific religion,
Yes.
we test it on the angle of Hindu religion.
Yes.
The religion has, in fact, been wave after wave of philosophical interrogations with self, with life, with nature, and if at all there is one maker. Now, in this exercise, various philosophers have put in their ideas, and these ideas have populated themselves into structures, which you say is the idea of Sampradaya. So in this situation, my question, that when a Sampradaya is created, and again a new philosophical challenge or a new philosophical idea creates an antithesis, a group evolves to that, will that become a new Sampradaya? That is what is the best.
Yes. It has to be. It has to be. It has to be. It has to be.
That is, you please proceed on your.
Yes, it has to be. That is
why it's not always immutable.
Yes.
The continuous way of interrogation with truth.
The truth. Because it is an offshoot of 25(1). Collectively, we believe something as our right, as a faith, and when it is transformed.
25(1) is individually a belief.
Individual. But when it comes to collectively.
It's individual beliefs.
Yes.
Coalesce, it forms a group.
Group.
And that is the Sampradaya.
Sampradaya. Collective.
Then again, that group, like every living organism, can multiply or even self-destruct.
That's correct.
And it can continue for generations to generation. And ultimately, it has to be proved in a particular given case, depending upon the set of facts placed before the court for consideration. Once it is a Sampradaya, and it is claimed to be a Sampradaya, that has to be protected, or even section thereof.
Ultimately, Sampradaya are the if we take the example of Hindu religion, we want to find the truth and ultimately salvation and moksha. There are various paths to that.
Correct.
They are represented by various Sampradayas, denominations. It's a manifestation of the various paths. There is no single path. Like other religions, in Hinduism, there is no single path to moksha.
No.
It is multiple.
Multiple.
You can, if you belong to a various, you say denomination or sampradaya, to reach ultimately the truth, the God, or attain salvation or moksha. So that is why the denomination has come in the context of Hindu religion.
It's not
so
correct.
therefore, there is no.
The path may be different.
Yes.
Not only Hindu religion,
goal is common.
Every other religion.
Yes.
All religions, it's like beautifully described one of the authors. He says it's rainwater. It gets in. It partakes different character. But it goes through different streams. But ultimately, they just merge
just in one point.
So they can, everyone will have a different route, but then the ultimate goal is the same.
Goal is that's
what Kabir says.
That's what it has to be. It has to be understood. It has to be done like that. This is the Sampradaya.
The beauty of the Hindu religion is that there are many paths. Unlike the other religions where there may be only one path. Here there are several paths. Therefore, several sampradayas or denominations has to make
different sampradayas. And collectively, and many times we have seen in the common parlance, collectively when it comes to many rituals, we call it as a Hindu sampradaya. Hindu itself can be a denomination collectively. Christianity itself can be a denomination. Islam can be a denomination. Then only it gets a complete protection. Depending upon the facts, you are able to prove it is a collective, the exercise of the faith or the collective exercise of your right and guarantee under 25(1).
About belief, it is not static.
It's not static.
It keeps changing. Only thing is you need to have an identified group. And then they combine together and then form the denomination.
Then it becomes sampradaya.
You can change from today, you have something tomorrow. Because enlightenment, wisdom comes only when there is a change.
On many times, even in the formally we read in the newspapers when the funeral and all takes place, we see it as it happened according to Hindu sampradaya, because collectively as per Hindu sampradaya it has happened, or it happened according to Vaishnava sampradaya. It can be Shaivite sampradaya. Everything is a denomination that has to be understood in the Indian context. It can be according to Christian sampradaya. It can be according to Islam sampradaya. And we need not probe to what extent that sampradaya is followed or not, whether that's a sampradaya or not. Collectively, it is called a religion itself can be a sampradaya. Religion itself is a denomination under Article 26.
17 last 2 to 3 lines.
Yes. Thus, the phrase religious denomination or any section thereof in Article 26 must be interpreted in Indic sense, informed by the concept of Sampradaya as reflected in the authoritative Hindi text of the Constitution. The interpretation must be rooted in India's unique, pluralistic, and culturally rich religious landscape. Only by adopting such an approach can the constitutional promise of religious autonomy be fully realized. To achieve the religious autonomy guaranteed under Article 26, this is the only and only interpretation permissible or possible. Next, I am coming to scope of the term matters of religion. Article 26, because it refers to the matters of religion. There in the Shirur Mutt case itself, the first sentence, only one sentence I would like to read in para 18. What then are matters of religion? The word religion has not been defined in the Constitution, and it is a term which is hardly susceptible to any of rigid definition. That exactly is the relatable even to Sampradaya. Once it is a religion, once it is a Sampradaya, and we can't give a definite definition for that. What constitutes a religion? There are basically, we can take three aspects, which is in the next page in para 19.
The form and manner.
The form and manner of worship, number one. Number two, the characteristics attributed to the deity. There is a plurality. A deity may have a different the character, especially when it comes to Hindu society. The third one, the observance and customs that define the religious practice. The observance, how it has to be, what are the things to be observed, and the customs that has to be followed. Collectively or individually, that can be basis for religion. Further, these matters lie within the exclusive domain. These matters lie within the exclusive domain of the denomination and not amenable to external scrutiny. Now, which I mean with due respect, normally when it comes to judicial scrutiny, whether this is a particular sampradaya which is correct or not, whether it has to be followed or not, that cannot be assessed by an external body. That is what that.
Mr. Nataraj, nobody says that as the first instance, the court decides what is the sampradaya or what is the religious practice or the matters of religion administered by the sampradaya. If the courts come into question when there is a conflict in these facts. The group says this is a sampradaya, whereas the other group says this is not a sampradaya, or a group say, or a member of the sampradaya itself says that this is not the form of worship.
Correct.
There, the courts necessarily require
On the basis of evidence.
Exactly, sir. Because of Section 9 of the Civil Procedure Code. Any question where there is a divergence or a conflict requires to be resolved through the process of adjudicatory mechanisms. To say that this cannot be answered by the court appears to be a very, it actually
no, certainly in a particular properly instituted suit.
Nobody questions the Sampradaya's right to define itself or to define its religious practices. But what happens when the Sampradaya's rights as to the religious practices are themselves in challenge? That whether you must have a fast before you go to the temple, or you must pray in a particular manner. Who will decide when the two groups or two members of the same sampradaya are challenging?
Yes, when there are competing groups.
Yes.
When there are competing claims, then based upon the evidence.
We are not on the mechanism of,
yes.
We are on the forum.
Yes.
The forum is nothing but the court. And there the court necessarily has to decide.
Absolutely.
As a matter of issue, that this is a sampradaya. This sampradaya had a particular religious practice.
Yes.
And this is the religious practice and not what you are controverting. This will also come into play when, let us say, a non-believer who is also having conscience of non-belief, says my right of conscience is in conflict with your Sampradaya's matters of religion, where a non-believer can also bring into question the matters of religion of a particular Sampradaya. This is what we would read.
That's right.
Because it cannot be that exclusion of courts.
No, I'm not saying, definitely not. Definitely not. Kindly don't take that.
Easy or a very clear, inferable propositions.
Yeah.
They must be expressly excluded or most necessary
Yes.
have to be excluded unless because of the context.
Yes.
This is not a situation like that.
Kindly
But
do.
in Venkatramana Devaru,
Yes.
this court has said the context of matters of religion, a restrictive interpretation must be given having regard to Article 25(2).
2.
Therefore, you can't bring everything into matters of religion so as to prevent social reform. That is why they
Yes.
said balance it,
You have to balance.
but a restrictive interpretation must be given as to what is matters of religion. And at the same time, one cannot negate the other.
Yes.
25(2) cannot negate 26(b),
Correct.
and 26(b) cannot negate.
All the articles under the Constitution, especially Part 3, will have to be harmoniously construed or constructed. Nothing can be read in isolation. Especially Article 26 cannot be read as an island. It is not an island provision. So kindly now go to Roman 2. Harmonization of Article 26 with Article 25 is the essence of interpretation. Article 25 and 26 occupy the same normative plane within Part 3. Article 25 secures individual freedom of consciences and religious practice, while Article 26 protects the collective autonomy of religious denomination. Neither provision is textually subordinate to the other. 25 is not subordinate to 26, nor 26 subordinate to 25. Both will have to be read together. You have to harmonize.
I find it a bit difficult.
Yes.
How do you read the subject to other provisions of this part in 25(1) and its conspicuous absence in 26?
Yes.
It must be that the individual freedom of conscience, once coalesced into the collective,
Yes.
the collective has to be given some degree of reverence.
But without 25(1), can there be
Cannot be a 26(b).
26(b)?
Absolutely, that Mr. Nataraj, you are absolutely right. But when is, let us say, small atomic
Yes.
faith molecules coalesce into the Sampradaya,
Yes.
and the Sampradaya has a common denominatory religious belief.
Yes.
That common denominatory religious belief has some cohesive preference to the individual divergent views or individual divergent views beyond the Sampradaya. Sir, please see also 25(1), not of the Sampradaya itself, but also of views of others' conscience, where you see the conflict. Here, will you say that both stand on the same?
Neither is subordinate to the other.
Correct.
All right. Yeah.
There are three ways of looking at it.
Yes.
One can be, as my brother has said, it can be a dispute between the believer and the denomination.
Yes.
What extent, court, and which forum. The other will be a non-believer is saying in which case he goes out of the denomination.
Yes. Correct.
What extent? The third will be a denomination and you. The fourth is the role required to play by the court in these aspects. This is what they have to say.
You have to harmonize. Therefore,
Yes,
that is the only possible approach.
If it is a believer and the denomination, then usually you write yes, but that's it. Maybe it's a matter for suit and evidence.
You will
You have
not
to go there.
26(b) at a higher platform than 25(1). That is your answer.
Yes. You will have to understood or read together harmoniously, that both is Article 25(1) and and entire 26 will have to be read together.
See, when it comes between the state and the denomination, there is a conflict between the state's right under 25(2) and the right of a denomination under 26(b). Possibly that is where the question of essential religious practice comes in. And what is protected is an essential religious practice of that denomination. Otherwise, 25(2) reform can never happen. Everything cannot say, it is my sampradaya, don't touch it. You can't say that to the state.
Correct.
Or to the court. What is saved is the essential religious practice of that denomination. If there is anything else where reform is required, then the state can legislate.
For that matter,
Between 25(2) and 26.
yeah. For that matter, every religious practice or religious,
I think this may be only purely an academic debate,
Yeah.
because there is no conflict between 25(2) and 26 which might require any harmonization.
absolutely,
There is absolutely, these are two different kind of bills.
different kinds.
What is 25(2) is regulated only by three constitutional conditions: public order, morality, and health.
Yeah.
Unless somebody make out a case in these three exceptions,
Yeah.
everything is permissible 25(2).
25. Because 25(2), that controls both 25(1) and 26.
That's it.
So it is a mechanism to regulate both 25(1) and 26.
Please don't say that it controls.
Say that.
Not controls, the enabling provision.
Nothing contained in that article.
They throw light on each other.
Yeah.
That's all.
We'll put it this way, 25(2) tells you what is your jurisdiction. That is only with respect to the political and other things, and economic and other factors and the secular things.
Good.
It may be loosely connected with
Connected with
religious belief. And then the 25(2)(b),
Yes.
where you have got an extended role to play, like superstition, something is there, the larger interests of the society, including then one third one is with entry. These are the factors you can do.
Yeah.
So which means beyond it you are not supposed to go
Between
into.
those three exceptions.
Yes.
Right.
It's subject to other things. So which means if you don't do it, what extent the court can do it is other aspect.
Justice Bagchi's question precisely answered in para 24 of my submission. As stated above, the relationship between Article 25 and 26 must be one of harmonization. In so and so case, may in certain circumstances be balanced with the broader social objective. However, such balancing cannot result in the effacement of Article 26, which must retain substantive content and meaning. So 26 cannot be effaced at all completely, but in substantive form and its content, that has to be given some kind of weightage when it comes to Article 26. Notwithstanding, there is no expression of it is governed by Part 3. Then kindly come to Roman 3. Public.
You were absolutely right, and you also quoted Devaru.
Yes.
Venkatramana Devaru has said that.
Correct.
What is protected under 26?
6.
In the context of 25(2)(b).
Correct. 25.
A balance.
Correct. Absolutely.
One cannot negate the other.
That is the correct approach. That is my respectful submission to the court. Then kindly come to Roman 3. Public morality as the governing standard. It is submitted that the term morality in Article 25 and 26 must be understood as a public morality and not as an abstract notion of constitutional morality. The phrase public order, morality and health constitutes a cluster of external regulatory grounds, all of which are directed towards maintaining social and public order. The interpretation of morality must therefore be consistent with this context. For this purpose, no doubt article simply says that it is the public order, morality and health. But when actually it came to Constituent Assembly debates, which I have annexed in my written note at page, the last 3 pages, (236). 236. Yeah. starts from 234. That's a Constituent Assembly Debates, Volume 7, held on 6th December 1948. It was referred to as Draft Article 19. That is relatable to Article 25, or now it is Article 25. Now kindly turn to 236. Lakshmi Kanta Mitra. This Article 19 of the draft constitution, that's 25, confers on all persons the right to profess, practice and propagate any religion they like, but this right has been circumscribed by certain conditions which the state would be free to impose in the interest of public morality, public order and public health, and also insofar as the right conferred here does not conflict in any way with the other provisions of the elaborated under this part of the constitution. So actually, the debate was actually to bring in was the public morality, public order, and public health. It is only draftsman's the convenience to say that it is the public omitting public morality and bringing only public order, morality, and health.
But it's yes, also.
Yes. So therefore, the standard which has been applied then was only the public morality, not the constitutional morality. Once public morality itself is the guiding or the light under which we have to read the provision, then it is the public morality, and that alone has to guide us to interpret the religious rights, nothing else. Then in para 27, the constitutional text does not recognize or employ the concept of constitutional morality as a limitation on religious freedom. Therefore, importing such a standard would amount to judicial overreach. The role of courts is limited to examine whether a practice violates the rights guaranteed under Part 3 of the Constitution, and not to independently determine or redefine morality. We need not examine or we need not redefine what would be the constitutional morality, what is the morality, or what is the standard of morality. That we need not define, because Constitution itself guides us to take it as a public morality, and that has to be followed. Then kindly come to Roman 4, unsustainability of the essential religious practice, REP doctrine, ERP doctrine. By the test of essential religious practice that cannot be accepted, I put it on for two grounds. Number one, at ERP, that is essential religious practice, lacks textual foundation in the Constitution. The Constitution under Article 25 and 26 only recognize the distinction between the religious practice and the secular practice. Article 25 protects the right to practice, profess, propagate religion simpliciter while reserving the state's power so and so. It is pertinent to note that the terms religion and religious practice used in Article 25 and 26 are not qualified by any restrictive words so as to narrow down the scope thereof. In the absence of any qualifying or restrictive word or phrase, the terms religion and religious practice should be interpreted to give wide interpretation. So when Article 25 or 26 employs only the religious practice, there is no question of bringing something else, reading it with a different meaning as an essential or in the restrictive sense. That is not permissible.
Who has it entered then the constitutional discourse? Essential religious practice has come about in which case? Is it a judicial invention?
It is a judicial invention as it developed.
First decision.
Yes, we have addressed in the subsequent paras, we have addressed it. Now in para 29, as can be seen under 25 and 26, do not draw any distinction between religious practice that are essential and those are non-essential. Absolutely, there is nothing. What is protected under 25, 26 are all religious practices are protected. Then only limitation would be part 3.
Which is that case where this discussion on essential religious practice happened?
Yes, kindly turn to. That is in first time that has been wrongly applied or interpreted in Dargah Committee, Ajmer Dargah Committee case.
Not in Shirur Math.
Not in Shirur Math.
That was under 26.
Yes, it was wrongly applied.
Under 26.
The argument is taken by the Attorney General in Shirur Math and it's recorded. At the
You
top
know,
of page, in Shirur Mutt, at the top of page 180. That is his argument,
Given its due importance there.
perhaps, but it was first argued there.
Paragraph 33 of your note.
Correct.
Paragraph 53 of your note.
Correct.
Please read that.
Yeah.
That is where Shirur Mutt
Shirur Mutt.
uses the word essential religious practice to explain the argument of the Attorney General. Attorney General was making a distinction between essential and non-essential. And Shirur Mutt says that anything connected with the religion is essential.
Yes.
Anything which is associated with the religion through secular activity is a secular.
And that was later misinterpreted or wrongly interpreted in Ajmer Dargah case.
No, before that, in Justice Gajendra Gadkar, using the word essential religious practice invents the outer layer of superstition.
That's in Dargah committee case.
Yeah.
That's in Dargah committee case.
Govind Raji.
That's a, yes, Tilkait case. Tilkait case.
First, it is noted in Shirur, accepted in Trilokya. In Trilokya.
Tilkait.
Sorry.
Tilkait.
Tilkait. Govind Raji.
Govind Raji.
That Rajasthan temple.
But Dargah is before, just about a month before or so.
Yes, almost one.
Yes, yes. By the same author.
Same, that's Justice Rajendra.
Yes. So in para 30, I specifically pointed out when the article 25 and 26, both the articles do not refer to.
Mr. Nataraj, if the Sampradaya has various rights and customs, and as you will find in all religions, as in law, there are mandatory customs, there are directory customs. Now, if we get a bouquet of customs, some mandatory, and thereby essential, and some non-mandatory or discretionary, and thereby non-essential, do you say that the idea of essentiality of custom to the very ethos of the tenet will not be a relatable factor?
That depends upon the faith of an.
It depends on the facts. Yes, you're right.
And the faith.
But you're saying that, take your submission, that the essentiality is not posited on religious, on secular character, but with its relation or relatable to the tenet and the belief of the Sampradaya.
Even by not following that particular tenet, you cannot be excommunicated. You have independent right of existence, either to follow or not to follow. As a non-believer, you can continue.
And that is the question
That's
I put to you. That the challenge can be by a non-believer of a believer's existing custom interfering with his freedom of conscience.
He can't, because he is a non-believer. He does not believe in that particular Sampradaya. His belief is something else.
Correct.
As a non-believer, he has an independent belief that I don't believe.
And therefore, I have a right to interrogate.
He can't interfere in others' right.
His belief
is
to question. His belief is to interrogate. Think of an atheist. An atheist's belief and his right to profess atheism is to interrogate the belief of another. And therefore, if he goes into an exercise to test the belief of others, belief is said to not exercise his powers under constitutional right under 25(1). And there is my question to you, that an atheist propounding his right under 25(1), will he or will he not be subjected to the Sampradaya's collective faith of matters under 26?
He can introspect. He can't question somebody else. He has a right to introspect. He can't question somebody's right.
Ultimately,
There is no question of, there is no common belief.
Yes.
There is no common
Belief.
belief. How do we come into the?
It can't be invented.
Mr. Nataraj,
Yes.
belief is something common, whether atheist or agnostic or a believer in any religion, it is belief. That is conscience.
Perfect.
I think now
His right will get restricted only to agree to disagree.
Disagree.
That's all.
That's all. Nothing beyond that. You can't question somebody believes it. You can't question it. You can't say that that's wrong. You can introspect yourself and say that, yes, I don't believe it. It's not acceptable to me. That's fine. Perfectly fine.
Yes, on para 31.
Yes.
Thereby, you are saying that 26B,
Yes.
the collective belief of a sampradaya,
Uh.
will eclipse the belief of the non-believer to practice or profess something under 25.1.
26, they have
That
the,
is where I was.
believers have that right. Right is guaranteed. Believers' right is guaranteed, and that cannot be eclipsed by non-believers.
Power right under 25.1.
Can't be. 25, that belief of non-believer, that is confined to himself.
That is what we are
Yes.
asking you. That is why I was again putting this question to you, that will you put them on equal platform when it comes to a contrarian believer?
Yes.
Now I've got your answer on
Yes. That's. Now kindly go to para 32. The first one I pointed out with regard to essential religious practice, there is a no textual foundation. That is the first one I said in para 28 onwards. Insofar as whether it's essential or not, when we test in the Indian context, let us take this major religion of Hinduism. There's nothing called it is mandatory. If you want to, you follow it, or if you don't follow it, you leave it. There is no particular text as such which has to be followed. So therefore, in the absence of textual foundation, the essentiality test cannot be applied, number one. Number two, in the Indian religious landscape in para 32, how I have put it, the doctrine of essential religious practice presupposes the existence of certain subset of religious practices that are essential to a particular religion. The said presupposition is inherently flawed in as much as no particular practice can be called essential to a religion to the exclusion of other. The religious practice are a matter of faith, and faith differs from community to community and from individual to individual. In such a situation, deeming certain practices to be essential to a religion or religious denomination to the exclusion of others would lead to securing fundamental right to one and at the same time denying it to the other.
So it is said Hinduism is ultimately a way of life.
Way of life.
Even though a person does not go to a temple
Yes.
or pray
Yes.
or worship, he
Yes.
still remains a Hindu.
Yes. Correct. Still here. As a non-believer also, he can survive as a Hindu. Kindly go to para 33 to 35, 3 para. For example, Hindu religion encompasses many religious practices, and no particular practice is or more essential than others. Many religious practices are not derived from any particular codified text and may be based on various sources, including scriptures, customs, traditions, or beliefs. The religious practices that arise from any of the aforesaid sources are ultimately based on faith, which varies from community to community and from individual to individual. The diversity is evident from the fact that Hinduism embraces both believer as well as non-believer. This inherent plurality makes it impossible to identify any practice as universally essential to Hinduism. The essence of the rigid doctrinal structure, the absence of rigid doctrinal structure further reinforces the argument that essential religious practice test is inapplicable, where diversity itself is the defining character. As such, deeming any particular practice as essential would be an anathema to the very foundation of the rights guaranteed under Article 25 and 26. The Constitution must be interpreted to protect such rights and not to destroy them. Which means the diversity is the one of the basic structure which is recognized under the Constitution. When there is a plurality, when there is a diversity, you must respect everyone. The right of every individual has to be respected. That has to be protected. So we can't say that it is essential and that alone is protected. When there is a multiple practices, multiple faiths, multiple sects, multiple beliefs, you can't say that we protect only this particular as against the claim of the other. Everyone has to be protected. Every right has to be protected. Then para 34, the right under Article 25 and 26 is guaranteed only to believers and not to non-believers, inasmuch as a non-believer has no right to invade the right of a believer. That is the precise answer question posed to Justice Bakshi. The non-believer has no right to invade the right of a believer.
Here you are putting beyond Devaru.
Yes.
Devaru says that there should be a proportionality between the non-believer's rights expression and the believers, Article 26 be matter of religion.
Not to invade the right of the believers. Therefore, it has to be harmonized. You can protect your right as a non-believer. You can go to the court or you can say anywhere, yes, this is my right to not to believe. But I have no right to.
So long as it is not imposed.
Yes.
They have no right to poke their nose into others.
Correct.
It's as simple.
That exactly.
To put it
Article
simply.
26 does not give rise to a horizontal right,
No.
only against the state.
State. Only against state.
There's no horizontal right.
Yes. Let us take in many of the temples, only the vegetarian food is served. I'm giving an example. And a person by choice or by conscience, he says that I want to have. You can't say, go to a particular denominational temple and say, yes, I have a right to have the particular non-vegetarian food. Therefore, I can eat it. It has to be served to me. He has no such right to invade the right of those believers under the denomination or under any religion. Similarly, liquor. In some of the temples, even liquor is given as a prasadam. Tomorrow, you can't object by saying that, yes, you don't give a liquor as a tirtham or prasadam in a particular temple. In many temples, we have seen, liquor is also given as a tirtham in many South Indian temples.
Only subject to the directive
South,
principles of
yes,
South,
north, east, west, everywhere.
Yes.
We have heard the learned SG and you to our mind.
Yeah.
I think we are trying to complicate things which is not
Exactly. There is no need.
As the Honorable Chief has said.
Yeah.
If you read Article 25, it gives adequate protection to the individual to profess. Subject to only three riders.
Yes.
That is public order, morality, or health. You can say constitutional morality,
Yeah.
public morality,
Yeah.
this and that.
Yeah.
As my brother has again said, 26(2) is only an enabling profession. And while enabling, it also restricts you. Which means 26(2)(b), you can do it only that involves a public health, public morality, and public order.
Absolutely.
That, I think any other interpretation would again, then it will not make any sense.
That will
That
destroy.
is because it gives protection to the person. The non-believer, this and that fight. This right to profess, practice, and propagate is subject to public order, morality, and health.
Well,
And when these are not, if they are not followed, other things,
Right.
you can step in and incidentally court can test and verify that to what extent we can interfere.
absolutely. Perfect.
That is our understanding
Yes.
so far as the arguments are concerned, which is
What-
balance to know what we do.
But
So according to you, matters of religion must be given a broad interpretation.
broad interpretation. Broadest interpretation will have to be given. Then para 35. Any interpretation imposing test of essentiality or centrality would affect the rights of several others following such a faith, practice, and in any interpretation so and so. Adversely affecting the faith in the absence of their participation in the legal proceedings would result in destruction of their faith as non-essential. Let us take in a particular proceedings, if you try to decide whether it's essential or not, there may be many people who may be having a similar faith, who may not be able to participate in such an adversarial situation. That may affect their faith or the right also.
You can always.
So we need not go into all those issues.
We can always convert the case into a
Yes.
representative.
Yes.
About Shirul Math, we have understood that well.
Yes. Then para 38. Further, the ERP doctrine necessarily requires the
court to implement.
ERP doctrine necessarily requires the court to determine whether a particular practice is essential to a religion. It is respectfully submitted that such an inquiry lies beyond the institutional competence of the constitutional courts. To decide whether it's essential or not, to what extent whether it's a particular is essential or not, that is normally not for the court unless there are two competing, as Justice Bhakti put it, there are two rival claims with regard to particular sampradaya, there necessarily court has to step in. Otherwise, it is not for the court to decide whether it is essential or not, or whether it's what type of practice we have
As against the state.
as against the state. Then correct constitutional approach in para D. It is therefore submitted that the correct approach is the threshold inquiry into the religious character of the practice rather than its essentiality. Once it is established that the practice is religious in nature, it attracts constitutional protection under Article 25 and 26. Once it is religious, it gets complete protection under 25 and 26, subject to Part 3 and other rigors. Then once a practice is essential to the religious, the role of the court is limited, so and so, same thing. I do not want to repeat. Then para 5, the last one, Roman 5, another nuance of the right of devotee. Manifestations of deities will transform to faith and practice and protected under Article 25 and 26. In Ramajanma Bhoomi case and in curtain of decisions earlier, especially from Tamil Nadu, Madras High Court judgments, it has been recognized that the deity is the juristic person. He has some right. The right of the deity that includes what are the observances, what are the things you have to follow in a particular institution. He has such a right. If he has such a right, it relates to the right of an individual guaranteed under Article 25(1). That's a faith. Now the right, sir. Sir. I'm sorry. I'm grateful, sir. I'm proud.
Contradictions.
Then para 42, the Hindu tradition, the management of affairs of a temple and how worship is to be conducted is intrinsically a matter of faith for the devotee, and what is regarded as a faith is often understood as a manifestation of will of the deity. In Hindu context, such manifestation is not always directly traceable to written scriptures. Rather, it is often embedded in faith that has been transmitted across generations, whether brought through scriptures, customs, or long-standing traditions. This continuity of belief forms the foundation of religious practice. The manifestation of the deity's will is not uniform. It may vary from institution to institution, community to community, village to village, and even from individual to individual. There is therefore no fixed or universal formula governing such thing. Para 43 and 45, last three paras, and I would like to conclude. Such manifestation of the will of the deity, which as stated above, is nothing but the faith of the devotees and is protected under Article 25 and 26 of the Constitution, as the right of the devotees to practice their religion and the right of the denomination to manage the affairs. Therefore, the protecting the right of the deity would amount to protecting the right of the devotee as well. Similarly, protecting the right of the devotee would necessarily entail protecting the right of the deity. In other words, both rights are interconnected and cannot be viewed in isolation. Any deviation from such manifestation risks the erosion of customs and beliefs of the devotees, as well as the integrity of the religious denomination, both rights protected under Article 25 and 26. Accordingly, the manifestation of the deity's will, as expressed through faith, cannot be disregarded or extinguished merely by interpretative exercise of constitutional provisions without a thorough examination of the factual matrix. The Constitution was never intended to abrogate or undermine such manifestation of faith, which lie at the core of religious freedom but are protected under Article 25 and 26. The last para, when a claim is made in derogation of this manifestation of deity's will, the issue must be adjudicated on the basis of the proper material evidence. Further, as stated previously, non-believers cannot make a claim destroying the manifestation of the will of the deity, which is protected in Article 25 and 26 as the right of the believers to practice their faith. So if in a particular temple or a particular institution, the deity has a particular manifestation to follow a particular practice or custom, that transfers into the right of the devotees as well. They are interconnected. And that is referable to Article 25(1).
That is a matter of religion.
A matter of religion. So therefore, a non-believer cannot come and say that, yes, the deity can't do it or the devotee can't do it. It is an issue between the deity and devotee.
Specific you want to point out from the Constituent Assembly debate which you had, 1.5 pages which are there.
That is the same thing about the constitutional morality which I pointed out.
statement by Mr. Muhammad Ismail Khan.
Yes.
7.6, 7.75.
Yes, 7.5, correct.
Maybe some relevance.
Yes. The question of professing, practicing, and propagating one's faith is a right which the human being had from the very beginning of time, and that has been recognized as an inalienable right of every human being, not only in this land, but the whole world over. And I think that nothing should be done to affect that right of a man as a human being. That part of the article is, as it stands, is properly worded, and it should stand as it is. That is my view. Perfect.
To preserve Sanatana Dharma insofar as Hinduism is
That's all.
concerned.
That's all.
Similarly, to preserve
Other religions, they have.
practices also in other religions.
Yes. If Article 26 is construed as very in a very narrow compass, as it is limited to denomination, means only a sect, then no institution, whether it's a mosque, whether it's a church, or whether it's a temple, will not get any protection under the Constitution. There is no other provision under the Constitution which protects any of the public temples or any of the churches or any of the mosques. The complete protection what we get, it's only from Article 26. For that purpose, all the institutions collectively, whether it's a religion or individually or section thereof, will have to be construed.
Consequently, that will destroy Article 25 also.
Correct.
Yeah, they cannot say they are separated there. So, as you rightly said.
So,
Subject to that.
with this one, I'm grateful for the. I'll take a little more time.
5
I'm
minutes.
grateful.
All right, all right.
I'll just-
You are appearing for whom?
Well, it's on behalf of the union. Well, it's
Can you?
two minutes. I think everything has.
All right, 2 minutes. Yes, yes. Let's start.
Malat, my time starts, Malat. My submission is this, that largely what has been addressed by Mr. Nataraj, I'm not going to take one more. I had 2 points. The first is, Lordship has read Article 394A, which is that there has to be, and there is an authoritative Hindi version. This is not a translation, it is the Hindi version. That is what it is to be taken as. Now, in terms of which, my first submission was, which has been addressed, which I'm not going to address, is by Mr. Nataraj, when he says that religious denomination has to be interpreted as Sampradaya. So, Malaj, I have in my note addressed that in great detail. I am not addressing it for the other. My lords will see the other two provisions, both 25 and 26. For the word morals, the word which is used in the Hindi version of both is the word sadachar. Approved sadachar, my lords, I have described in detail. Sadachar means approved custom. And there is no scope in this. In short, well, that note is on record. There is no scope for something like constitutional morality to be read into morality under these two provisions. When the word is sadachar, and there's a long description as to history of what is sadachar. Well, as I've described what Kane says is sadachar, in terms of what the Brihat Hindi Kosh says, Acha Acharan is sadachar. That's direct Hindi translation. And I've described all, including the provisions, including judgments of this honorable court, which says approved custom over a period of time. So there is no question of the exercise of constitutional morality to be read in, because that's an objective which everybody wants to reach in future, while in the present case, sadachar is something which has already existed and you think that's the best possible exercise. So morality to that extent will have to also be read as sadachar. And my lord, since lordships, yes,
not redundant to constitution, it is applicable to constitutional functionaries.
Yes,
how to function under the constitution is a aspect. Their constitutional morality comes in the context of conventions, structures, etc.
Yes, that was
but not in the context of 25-26.
Well, that was the way the Greeks, lordships are right. That was in context. That was the way the Greeks understood it. Daisy understood it, is to have an understanding that the constitution, that to respect of the constitution is actually constitutional morality. It cannot be used as a constitutional instrument to interpret or circumscribe Article 25 and 26, because that is not what was envisaged at all. And if lordships are taking some sort of, and lordships have spoken about a Swadeshi interpretation of the constitution in that presidential reference, the governor's reference as to the bills, that I have also quoted.
So you have reproduced 25 in Hindi version.
Yes, ma'am.
Lok Vyavastha, Sadachar or Swasth.
Yes,
These are the three components.
yes, Lok Vyavastha,
Lok
Sadachar
Vyavastha, Sadachar
or Swasth.
or Swasth.
Swasth, that's health.
Lok Vyavastha is public order.
Public order.
Public.
Approximately public order. Malaz, I could go down and explain that that's not perfectly public order, but approximately public order.
What is the Hindi version of public order in the constitution?
Lok Vyavastha.
Lok Vyavastha.
Lok Vyavastha. In Bengali, we would say Lok Vyavastha is the same, more or less, approximately the same thing. So in the crux, Malaz, lordships have talked about a Swadeshi interpretation of the constitution recently. And I would...
We have also seen your the dictionary meaning of Brihat Hindi Kosh.
Yes, yes.
So,
Acha Acharan. That's the official dictionary.
Publication.
Yes,
It's an official
publication. Malaz.
Brihat Hindi Kosh. Sadacharan means Acha Acharan.
Acha Acharan.
One Sahat.
Sadacharan. Acha Acharan Wala Purush, Dharmatma, Sadachari. That also Malaz. So there is no scope of reading in something like constitutional morality.
और सदाचारी को तो बहुत ही सम्मानित शब्द दिया गया, धर्मात्मा तक बोल दिया गया. अगर आप सदाचारी हैं तो you can be.
You're a good person. You're a good person. You're a good person.
Will you,
Well, as the background
will you equate Sadachar with justice, equity, and good conscience?
Well, Sadachar in this context, in the context of the provision, has been used as a interchangeable, approximate interchangeable with morality.
Because Acche Acharan,
Sat Acharan. Sat Acharan.
justice, equity, and good conscience.
Well, it's,
Will that be a
well, it's, well, it's my,
comparison?
well, there would be an element of custom which goes with Sadachar, because Achar will be custom, which I think equity, equity, good conscience.
When Yaggavalkar.
Yes, yes. Well, we've quoted all that. We've quoted all that. That's,
Dharmaraya.
Paragraph 20.
yes.
So,
Approved customs or use.
Approved custom. Lordships are right. That's the word which I had highlighted to highlight to the court. Sampradaya has been addressed in great detail by my learned friend, so I'm not addressing. But that's about all. Obligements.
All right, thank you.
I'm sorry, I'm not taking any more time. Whatever has been addressed in excess.
Lordship, a very small thing regarding what my learned senior on the other side said.
We will give you chance.
Lordship, a very small thing. He said Sadachar means Acha Acharan. Then how can a 10-year-old girl who is being discriminated?
No, he's not saying.
So how it can be Acha Acharan?
He has only reproduced the dictionary. It's not that.
He said in context of the matter. So in the matter, if a 10-year girl goes to temple, they say the temple becomes impure. So how it can be Acha Acharan?
We will see.
It can't be.
Wait, please, Lord. I beg to appear on behalf of review petitioners, Nair Service Society. Yes. We have just handed over a statement.
Yes,
yes, Nair Service Society, which has been representing the devotees throughout, and Ayyappa Seva Samajam, and Kerala Kshetra Samrakshana Samiti. These are the devotees organizations in Kerala. And I also represent an intervener, that's the
society, then Sabarimala Ayyappa Seva Samajam.
Yes.
Then Kerala
Kshetra Samrakshana Samiti. That's right. And Matrua Samiti, that's a women's organization of the Kerala Kshetra Samrakshana.
Dharma Hindu
and the Dharma Hindu Acharya Sabha, Hindu Dharma Acharya Sabha, representing 133 Sampradayas, which was started by Dayanand Saraswati. And I am representing them. I have given a written submission which is part of the record, I-1, starting at page 168 to 255. I have copies of that. And in the light of the specific questions which my lords have been raising, I have given an additional submission. Because on the interplay of Article 25(2) and Article 26, which has been one of the issues which have been troubling my lords, I have given a separate note. I shall place that more elaborately. My first submission, I will rush through. I won't take much time. But the second one, I will deal a little more elaborately because that has raised the question. That deals with the questions that have been raised. I believe the copies have been given of my submissions. If my lords will kindly come to from pages. Yes. Page 1 to 4. Yeah, first one. First one. Yes, part of the compilation.
What you have given today,
I'm sorry.
the submissions you have given today, you are referring to that now?
There are first volume. First submission is volume 1, Roman 1.1 at page 168, but I have given copies for my lord's convenience. And the second one perhaps has not been uploaded because that is prepared in answer to my lord's question.
Which one you want to start first, Mr. Vaidya?
Roman 1.1 at page 168, I have given copies.
168?
Yes.
Yes, yes.
The spiral bound. It is in the spiral bound volume.
Yes, we have got it.
Yes, spiral bound volume.
Actually, it starts from page 170, where you have
very well, page 170. What I have done is at page 1, the issues, and I have given the synopsis from page 1 to 4, and at page 5, I deal with issues 1 and 2. That's internal page 5, perhaps page 174 or 174. Yes.
Where you start meaning and scope of religion.
That's right. Meaning and scope of religion. That has been elaborately dealt with. I don't want to go into it. Where Shirur Mutt and those cases have been dealt with. And internal page 8, the heading, Article 25 protects both individual and collective religious practice, not just individual, but collective also. That's how the courts have approached. I have given the extract. And I will read only at page 10, also the international covenants, paragraph 14. International human rights instruments also recognize the freedom of religion. I refer to Universal Declaration.
What has not been read before us?
Yes, that's right.
It's interesting.
Yeah.
Is para 7 at page 8. We are not in such great hurry. You can read para 7 also.
Yes, para 7. In the gods have distinct forms ascribed by the Article 25 also protects religious rights of persons with respect to the deity. This also protects the right to worship a specific manifestation of deity, which has to be articulated and understood as per tenets of religious faith, belief practices. In Devaru, Venkatramana Devaru, the gods have distinct forms ascribed to them, and their worship at home and in temples.
Read this small paragraph.
Yes.
In Devaru, para 17, this court said?
Yes. The gods have distinct forms ascribed to them, and their worship at home and in temples is ordained as certain means of attaining salvation. These injunctions have had such a powerful hold over the minds of the people that daily worship of the deity in temple came to be regarded as one of the obligatory duties of a Hindu. Though we are not worshipping the idol, we are worshipping the Brahman. Ultimately, it is a supreme being that we worship, but through the form of this idol. And this has been in our sampradaya, in our Sanatana Dharma, this has been one of the things which has been well established, well recognized. And that's this is a right. As my lords earlier read the Constituent Assembly debates also, Right is not conferred for the first time under the Constitution. Right is pre-existing. It is only recognized.
Recognition of that right.
Yes, it's only recognized. May continue.
Inalienable right.
That's right.
It doesn't depend upon the constitution giving it
Yes.
or taking away.
We continue at 2 p.m.
Okay. I'm great. show that paragraph 14.
Paragraph 14.
Yes, ma'am. Paragraph 14. The international human rights instruments also recognize the freedom of thought, conscience, and religion, either alone or in community with others. Therefore, individual rights as well as the collective rights, community rights. And similarly, Article 18.1 of the International Covenant on Civil and Political Rights. Therefore, consistent judicial position therefore demonstrate constitutional guarantees of religious freedom protect both individual belief. I'm sorry, my lord.
Page 179.
Page 179, perhaps.
Page 179 or
Yes, yes.
Internal page 10.
Yes, internal page.
Yes.
My lord, sir. Yes, sir.
15, 16 also.
I'm sorry.
15, 17.
Yes. Therefore, these show that individual belief, collective practice, these are protected. Yes, read. Yes, I'll read. Understanding was reiterated and elaborated in Article 18.1 of the International Covenant on Civil and Political Rights, which guarantees freedom of religion, including freedom to manifest religion, either individually or in community with others, and in public or private. In public or private, in worship, observance, practice, and teaching, these instruments thus recognize that the exercise of religion is often realized through collective practices and shared religious institutions. That's our submission. The consistent judicial position, therefore, demonstrates that the constitutional guarantees of religious freedom protects both individual belief and collective practice of religion by communities of believers. Opposite understanding of in points A and B is also consistent with the constitutional commitment to liberty of thought, expression, belief, faith, and worship, which is in the preamble. Then, Millard, I have set out about the constitutional scheme of Article 25. Millard, I'll deal elaborately with this, Millard, because 25.2 will have to be explained, Millard. There is a slight divergence of view between us and what central government has presented. Millard, I'll deal with that. Millard, para 21. Therefore, Millard, just to indicate the submission, 25.2b therefore operates as a specific constitutional power of social reform within the domain of religion. The fact that it is not authorizing religious reform. It talks of social reform. It's not authorizing religious reform. That's important because, and Millard, the second, there are two parts to it, which I will explain, Millard. Millard, in D, para 23, I am giving the legislative history, and Millard, only to show in the context of the specific Millard, finding in Sabarimala case about right of women. Millard, Article 15, as it stands today, was sought to be amended during the course of the Constituent Assembly debates to include also places of worship. And this amendment was rejected. Article 15 amendment in regard to throwing open the various places of parks, various other amenities, etc. The amendment that was sought was you must include place of public worship. That amendment was rejected. And the right of access, entry, etc. into places of public worship is specifically dealt with only, if at all, by any legislation that can be made pursuant to Article 25.2b. We can't invoke general provisions of 15, 16, and various other provisions. And my lord knows, Article 29 and 30 also do not talk about gender or sex, because we have in our history had institutions exclusively for girls, exclusively for boys. There are today a large number of co-educational institutions, but nobody wanted to make it mandatory to enable Parliament or legislature to make laws which will make it compulsory that it should be co-educational institutions. Therefore, that part was kept out. I'm just giving an analogy. Now, if my lords will kindly go to para 26. It is submitted that access to public use of a secular nature is guaranteed under Article 15.2 on all counts: religion, race, caste, sex, place of birth. Article 15.3 and 4 secure educational empowerment for scheduled castes and scheduled tribes. Article 16.1 guarantees equality in matters of employment under the state, while Article 16.4, 4A and 4B secures social and economic empowerment of scheduled castes and tribes by enabling reservation. Article 330 and 332 secure political empowerment to scheduled castes and tribes by providing for reservation of seats in the House of People and Legislative Assembly. Therefore, on the secular side, justice, social, economic, and political, and equality of status and opportunity is guaranteed to all by various persons and including scheduled castes and tribes. 335 ensures that claims of SC/ST members are taken into consideration. But otherwise, Article 17 deals with untouchability, specifically in the context of the past unfortunate historical practices. And that's why my lords in Nagaraj, which I quoted in para 27, insofar as religious institutions are concerned, social justice and equality is guaranteed. Core Hindu religious institutions of a public character alone, and not core institutions of other religions, or even private character, Hindu religious institutions of a private character, and in my respectful submission, even denominational character, if they do not throw it open. The reason is to give effect to the mandate of Article 17. And I have quoted Nagaraj, great social injustice resulted from treating sections of Hindu community as untouchable. And therefore, Article 17 abolished untouchability. And 25 permitted the state to make any law providing for throwing open all public Hindu religious temples to untouchables. Therefore, it is in that context nothing to do with gender or sex. 25(2)(b) is a targeted social reform provision, not religious reform. I am going to deal with it in that separate note. I will come to that. Para 32, on untouchability. Now kindly come to para 33. The heading. Article 25(2)(b) is not a general equality provision. Constitutional power to throw open temples to all classes and sections of Hindus is not a facet of general right. Sorry, 33, para 33, and the heading about that. If Article 25(2)(b) is not a general equality provision, the constitutional power to throw open temple to all classes and sections of Hindus is not a facet of general right to gender equality. The provision was introduced as a specific response to caste-based exclusion rooted in untouchability and must be understood within that limited constitutional context. The fact that the framers of the Constitution specifically empowered the state to enact laws, throwing open Hindu religious institutions to all classes, public institutions, to all classes and sections of Hindus, is constitutionally significant. If the equality guarantees contained in Article 14 or 15.2 were themselves sufficient to mandate universal access to temples, 25(2)(b) would serve no independent purpose. It would have been odious. Therefore, we have to give meaning. Then, the next one, I want to, this has been dealt with by the learned solicitor on religious denomination. I want to, my submission is going to be, in Shirur Mutt, when reference was made to the Oxford Dictionary and three conditions were set out, this was not considered by the court in Shirur Mutt to be mandatory requirement. This was only an extract from the dictionary. The solicitor has already placed, and the learned additional solicitor also has placed the authorized Hindi version about Dharmik Sampradaya. I'll deal with that. And if my lords will kindly see para 39 and 40, this is our respectful submission. The court did not lay down a rigid threefold test for identifying a religious denomination in Shirur Mutt. Besides, the court did not have the opportunity to refer to the authentic Hindi translation of the constitution, where the expression used is Dharmik Sampradaya. In the absence of that, they referred to the Oxford Dictionary, which was more concerned with the Abrahamic religions and not in the Hindu context. And unfortunately, in S.P. Mittal, when Sri Aurobindo Society was a petitioner, Sri Aurobindo Society was faced with a peculiar problem. This was during the emergency, particularly, when Sri Navjata, who had become a kind of successor after the Sri Aurobindo and the mother, and he was heading the institution. He had unfortunately fallen out with some persons who were in power, who had, because in Auroville, lots of foreigners were there, and then they had access to the powers that be. And this led to enactment of law. And they had to challenge it and challenge the validity of the Auroville takeover. That was the historical background of S.P. Mittal. Where, though Sri Aurobindo never said he's espousing a new religion, his was essentially one of integral yoga, and then achieving that every person is capable of raising to the level of supramental consciousness. Effectively, Advaitic concept, because Tattvamasi, Aham Brahmasmi, therefore raising yourself to the level of supramental consciousness. That was basically the philosophy of Sri Aurobindo. And when they were faced with the kind of takeover, they had to raise pleas. And I had drafted the petition, so I'm somewhat familiar with this case. And Mr. Saurabhji and Mr. Vanugopal had appeared. Mr. Saurabhji argued the aspect about religion, and Mr. Vanugopal had argued about religious denomination. The view, no, this is not separate religion. Now that problem was, they applied the tests of Abrahamic religion. They said it is only a philosophy. A philosophy is capable. What is our concept of understanding a religion? We never had anything like Hinduism as the term for our religion. It was Sanatana Dharma. That it is Hinduism is a concept of the colonial rulers in the last 2 centuries. Before that, it was never known as Hinduism. It was always Sanatana Dharma. Now, if we import all these tests in regard to Abrahamic religion and hold that Aurobindo's philosophy is not religion, that part was rejected. Then on the question of religious denomination, they said Shirur Mutt has referred to Oxford and set out the 3 conditions. The expression religious denomination must also satisfy 3 conditions. With the greatest respect, I appeal to my lords to kindly overrule this part of it. The test in regard to religious denomination, which has been laid down as if it is mandatory, I respectfully submit is incorrect. And the test adopted by Justice Chinnappa Reddy, kindly see the underlying portion which I have extracted in paragraph 41. Justice Chinnappa Reddy's dissenting view. We take care to mention here that whatever the ordinary features of a religious denomination may be considered to be, all are not of equal importance, and surely the common faith of the religious body is more important than the other features. And then Miller at the bottom of the page. Yes. It is perhaps necessary to say that judicial definitions are not statutory definitions. They are mere explanations, every word of which is not to be weighed in golden scale. Then Miller at the bottom of the page. Religious denomination has not to owe allegiance to any parent religion. Miller, this is very, very important because it is as if when we say religious denomination, it has to be of a particular religion. No, it is not necessary. It can either be a separate religion or it can be a denomination which is emanating from a particular religion, but it need not owe allegiance. Entire following of a religion may be no more than religious denomination. This may particularly be so in the case of small religious groups or developing religions, that is, religions in the formative stage. That is, when schism takes place. When in a religion schism takes place, a small groups takes a different view. It may not necessarily have the same common view. Now, Millard, I have referred thereafter in page 18, paragraph 44, to Sampradaya, and Millard, kindly read with me the definition given by Dr. Radhakrishnan and also Arnold Toynbee. Aboriginal tribes, savage and half-civilized people, the cultured Dravidians and the Vedic Aryans were all Hindus, as they were the sons of the same mother. The Hindu thinkers reckon with the striking fact that the men and women dwelling in India belong to different communities, worship different gods, and practice different rites. And Arnold Toynbee, in the present-day experiment in Western civilization, when we pass from the plane of social practice to the plane of intellectual outlook, Hinduism too comes out well by comparison with the religions and ideologies of the Southwest Asian group. In contrast to these, Hinduism has the same outlook as the pre-Christian and pre-Muslim religions and philosophies of the western half of the world. Like them, Hinduism takes it for granted that there is more than one valid approach to truth and to salvation, and that these different approaches are not only compatible with each other, but are complementary. That has been our dharma, while retaining an underlying and cultural, spiritual unity. The spread of distinct practices, practitioners, deities, rituals, and traditions across the subcontinent, therefore, reflect the inherent diversity of Hindu religious life. It is within this context that sampradayas emerge and should be understood. And Millard, I have extracted the Monia Williams Sanskrit English Dictionary. A traditional sampradaya means it can refer to the doctrine, it can refer to the sect. Because Millard, one of the things arising from the question that was raised this morning, Millard, therefore, there can be changes in the doctrines, but it can lead to a schism or it can lead to a new sect. A traditional doctrine can handed down, a sect, a particular system of religious teaching, traditional belief or usage. And Apte's Sanskrit English Dictionary, a traditional doctrine or religious system transmitted through successive teachers, a sect or established religious tradition. Then Millard, kindly come to para 47.
46 also, the root.
Yes, 46 also, Millard. The word itself derives from the word root, samprada, meaning to hand down or transmit, signifying a body of religious teaching, ritual practice, and discipline preserved through tradition. The agamas themselves are defined to be revealed teachings which has come down. A sampradaya is the lineage which transmits the teaching. The concept of sampradaya is closely connected with the principle of Guru Parampara, that is, the transmission of spiritual knowledge, ritual practice, and theological doctrine through a recognized lineage of teachers and disciples. Classical Hindu tradition have historically preserved their theological identity through such lineages, ensuring continuity of doctrine, discipline, and ritual observance across generations. The preservation of a sampradaya therefore depends upon the ability of the community of the worshippers and its spiritual religious authorities to maintain the distinctive practices and modes of worship associated with that lineage. Now, this unfortunately is something which has been missed out in the Sabarimala case. Therefore, their identification of what is a religious denomination and whether, therefore, the devotees of Ayyappa constitute a religious denomination, unfortunately, has failed to apply what, according to me, will be the appropriate test in the Hindu context, in our milieu, in our tradition. It is well known that the organization of Hindu religious life has accordingly taken place through such sampradayas, each characterized by shared theological understanding, recognized ritual practices, and a community of adherents bound by a common discipline of worship. These traditions frequently develop around particular deities, pilgrimage centers, or spiritual teachers, and are sustained through continuous practice rather than through a centralized ecclesiastical structure. We don't have a system of a pope, archbishops, and bishops, and that kind of an ecclesiastical structure we don't have.
That means in Hinduism, the Hindus there are Hindus who can belong to several sampradayas.
Yes.
But and they can visit any temple. There's no bar.
Yes.
But if the Hindus want to visit a particular temple, the sampradaya which is attached to that temple must be followed.
Yes, correct, exactly. I'm very, very grateful. Now, take the case of Ayyappa.
We are not, we don't have that rigid system.
Yes, correct.
All Hindus are Hindus.
Yes. Interestingly, in Sabarimala, no distinction is made. There is no bar to Christians or Muslims entering. They can also go. But if they must have the faith and belief in the divinity of Ayyappa. Therefore, you have to follow the Vratam, the 40-day Vratam, and whatever are the practices enjoined on the believers, and they go and approach. Nobody is prohibited from that. Therefore, this concept, unfortunately, has not been understood. It is not necessary that religious denomination means that a person should belong to a particular religion and then it is a sub-branch of that. It's not necessary.
Sure, like that.
Therefore, that unfortunately has erroneous understanding.
You may belong to one sampradaya, may follow one mutt. Nothing prevents you from going to another mutt or going to a temple which belongs to another sampradaya, but you must respect that.
Correct, exactly. In the Kashi Vishwanath case again,
differently. One does not have any choice except to go under the sampradaya, which is either attached to the temple or in a denomination. Because the moment you start questioning it, you go out of the denomination.
Correct, exactly. Then you are no longer in the sampradaya. You are a non-believer.
It's not even a question of laying a challenge because you are not part of the sampradaya.
Yeah.
If you are not the part of sampradaya, nothing to do with your personal belief. You can have your own personal belief.
Correct.
But you can't try to change the belief.
Yes.
Whether you go under it or leave it.
Correct. Under Article 25, you might have your individual belief, you are entitled.
That is protected, subject to the restriction given under 25.
Correct. But if you want to go to a temple or an institution belonging to a particular sampradaya, then you must believe in that sampradaya you must be part of that sampradaya, follow the practices of
For example,
sampradaya.
Kerala,
In North
in
India.
some temples, you have to wear dhoti. You can't wear shirt. You can't just go there. If you want to go, you can't say, I am entitled to wear shirt.
Correct.
If you want to do this, you don't do that. So,
Same example as my brother is giving.
Wear dhoti.
In some of the temples,
Is that
like
part of the?
Convenience sake, on pants, they put dhoti.
Outside the temple, Milad,
So-
you have dhoti and you can.
Some substantial compliance.
That's right. Milad. It's not actual compliance, but substantial.
like Guru Vayu temple, you can't wear the shirt.
Yes.
You have to remove the shirt
That's right.
when you want to go
That's
to
right.
Guru Vayu temple.
Go to a.
In North India, when you go to Gurudwara Sahib,
Gurudwara.
Golden Temple or any other Gurudwara, you have to wear the.
Correct. Milad, even in Vaishno Devi, if you are going for the arti, you have to cover up your head.
Millions of Hindus go in the Gurudwara, but they will have to.
Yes, we have to
maintain
cover.
that decorum.
Golden temple, we have to cover our head.
Yes.
Mr. Vaidyanath, and all these examples, actually show the precedence of 26 clause B with regard to its superiority in the managerial rights of religious affairs, which are manifested through these expressions of ritual, practice, etc., over the core internal belief, which is freedom of conscience and its rights of professing, practicing of religion. So a person who is a non-believer, even if he goes to a temple or a mutt or any institution managed by a denomination or a section of denomination, has to adhere to the religious affairs manifested through the rules.
Correct. That's right.
This is what you are.
Yes, that's right. That's my son.
And in this respect, the real conflict is the propagation of the non-believer of his right becoming eclipsed for that temporary period where he submits himself to the domain of the management of the affairs of the religious denomination.
Well, that person's
That does not mean that the visitor gives up his freedom of conscience not to accept it, but has to subject to it.
Correct.
Because if we hold otherwise, that the non-believer cannot interface, then we would be eroding the non-believer of his core freedom of conscience, even to profess. Because to profess, if you look from the contrarian view, a person who has to contradict a proposition must experience the proposition. So in doing that, the non-believer may subject himself, but need not accept the religious practices.
Correct. Well, the individual's freedom of conscience under Article 25 cannot defeat the freedom of the community or the denomination.
It's a more core esoteric thought.
So now, by virtue of this, you admit that Article 26 is not an island provision or island article or a standalone article.
Well, Article 26B is, I have a submission on that. Well, Article 26B is the right of the denomination in regard to religious practice, affairs of religion. Well, question is not whether it is an island provision, whether it can be controlled by 25(2)B. 25(2)A and 25(2)B. Well, if my lord will,
if you say 26B is an island provision or a standalone, that means you will canvassing, it is not governed by 25(2)B. By virtue of that, I go out of part 3 of the Constitution.
25 and 26 come under the heading right to freedom of religion. Therefore, it is not in that sense an island provision. But can the right under Article 26B, that is right of a denomination to manage its own affairs in matters of religion, be subjected to any law made pursuant to Article 25(2)B is perhaps the prime question which I have to address. I have dealt with it in a separate note. My respectful submission is it can't be. Shirur Mutt was concerned with 25(2)A. 25(2)(a) because it was the question therefore asked in Shirur Mat was the submission of the Attorney General, which is recorded at page 173 and 180, was, is this a secular aspect which can be regulated under 25(2)(a), or is it something to do with religion which can't be regulated under 25(2)(a)? That was the only limited aspect canvassed before the 7-judge bench. Now, Millard,
Scale of expenditure, the scale of expenditure
yeah,
for the purpose of an activity associated with religion, but not.
Correct. Therefore, which was regulating or restricting any economic, financial, political, or other secular activity. That was the question. That was the secular activity. Now, Millard.
In other words, you admit
Yeah.
25(2) has to be read along with 26.
No, I don't.
The reason
Millard, because
there is a reason, because
correct.
Union of India has canvassed.
Yes,
That
Millard, I am, yes, I agree, Millard. Therefore, I said I digress from that view.
So we wanted to know.
Yes, Millard.
You are in disagreement with that view of.
Yes, I am in disagreement with it.
Vaidyanathan is putting 26(2) at a higher pedestal.
Yes.
Than 25(2) because
25(2) is only an enabling power. 25(2) does not confer any right. It confers a power on the parliament or the legislature to make a law. 25(2). Therefore, now we are comparing one provision which gives an enabling power. 26 is a right which has been given. There is no comparison between the two. 26 has to prevail. 25(2) cannot. 25(2).
Venkatramana Devaru, both the provisions were considered. Venkatramana Devaru.
Venkatramana Devaru, in my respectful submission, has unfortunately laid down an incorrect law which needs to be overruled. We had to give.
We accept this proposition.
Yes.
This 26 is to be construed virtually in exclusion to 25(2). Then that means tomorrow there will be a situation where others will start asserting and say you will exclude X, Y, Z. You cannot.
With the greatest respect.
Part 3 steps in.
With great respect. With great respect. There can be temples. There can be private, there can be temples which are not public temples, denominational temples, which can exclude. I'm sorry?
Very high.
I think, Mr. Vaidyanathan, first you complete your argument because probably you are yet to read that note.
Yes.
Then probably we will be
Very well.
in a better position to understand and appreciate what you want.
This is a crucial question, I have to answer it. I have to, yes. Let me complete this note. When I come to that note, where I have dealt with it elaborately, I will answer that. Now, page 19, paragraph 50. The plural and internally diverse character. I'm sorry.
No, you are page 192.
That's right, 188, I think. Paragraph 50.
188.
Yes. The plural and internally diverse character of Hindu religious traditions has also been recognized by this Honorable Court. This recognition that religion includes distinctive rituals, observances, and modes of worship necessarily acknowledges that different religious communities and traditions may preserve their own doctrinal and ritual disciplines. In the Hindu religious context, such traditions have historically taken the form of distinct sampradayas organized around shared theological understanding and modes of worship. Then, I refer to 394A and religious denomination, the Hindi translation, Dharmic Sampradaya, I refer to that. And then, para 52, the constitutional guarantee of denominational autonomy must therefore be understood in the civilizational context. The protection afforded by Article 26 extends to religious traditions organized through sampradayas, whose continuity depends upon the preservation of the distinctive practices, discipline, and modes of worship Interpreting the expression religious denomination in a manner that disregards this traditional structure would overlook the historical organization of Hindu religious life that the Constitution itself seeks to protect. Then, I had referred to a passage of Justice Jagannath Reddy in Keshwananda Bharati, where he says, the underlying portion, that the Constitution will have to be interpreted and understood in the Indian context, Indian historical situation, and Indian the milieu. The seed of the Constitution is sown in a particular soil, and it is the nature and the quality of the soil and the climatic condition that prevalent there which will ensure its growth and determine the benefits which it confers on its people. We cannot plant the same seeds in a different climate and different soil and expect the same growth and same benefit therefrom. Law varies according to the requirements of time and place. Justice thus becomes a relative concept, varying from society to society according to the social milieu and economic conditions prevailing therein. Difficulty to my mind, which foreign cases or even cases decided within the Commonwealth, where the common law forms the basis of legal structure of that union, just as it is to a large extent the basis in this country, is that they are more often than not concerned with expounding and interpreting provisions of law which are not in pari materia with those we are called upon to consider. The problems which confront those courts in the background of the state of the society, the social and economic setup, the requirement of a people with a totally different ethics, philosophy, temperament, and outlook differentiate them from the problems and outlook which confront the courts in this country. Therefore, my lords have recently also stated that we have to look at our background. Therefore, we have to have an interpretation based on the Indian situation. That is, in the next page. Therefore, the conclusion is it is extremely unsafe to assume that a decision on one of them can be applied without qualification to another, that is in one jurisdiction, etc. And in Shirur, therefore, these now also come to, this is the holding of 7 judges. In answer to what my lords were asking me, we have to deal with this in spite of this holding in Shirur. How did Venkatramana Devaru take a slightly different view? The last 8 lines from the bottom, under Article 26B, therefore, a religious denominational organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of the religion they hold, and no outside authority has any jurisdiction to interfere with their decision in such matters. This includes not merely the judiciary, but even the legislature. And 25(2)B, that is again reiterated in the bench. I'll deal with that. Now, I have summed up the conclusion on this, in paragraph 56. Expression religious denomination occurring in 26 has been judicially interpreted by Shirur Mutt by reference to Oxford Dictionary meaning, which was subsequently reiterated in S.P. Mattel and later edition in the light of caution expressed in Keshwananda Bharati, continued reliance on a lexicography definition drawn from a foreign linguistic and historical context, particularly where the expression has been translated in Indian languages as Dharmic Sampradaya, requires reconsideration so that the meaning of the constitutional text may be understood in the civilizational, religious, and social context in which the Indian Constitution operates. Like then, on foreign jurisprudence, I have, Your Lordship may omit that, should be understood in the Indian context, not in the Abrahamic concept of organized religion. Then, I'll come to the group rights must prevail. Earlier, while answering my lords, I had said this, that individual may have a different point of view, but his point of view cannot be allowed to prevail in a manner that the collective's beliefs is destroyed. The religious denominations' beliefs or tenets are destroyed because the individual's right is asserted and will have to be given. That's a submission. And it's my respectful submission. Justice Chandrachud asked the wrong question and got the wrong answer, because he asked whether individual right should prevail over a group or collective religious right, and he held wrongly, in my respectful submission, that individual right can prevail over collective religious right. Now, kindly come to para 61. The constitutional recognition of the collective dimension of fundamental rights is not confined to religion alone. Constitution repeatedly protects the autonomy of communities in order to preserve their identity and institution. Articles 29 and 30, for instance, guarantee to linguistic and religious minorities the right to conserve their culture and establish and administer educational institutions of their choice. These provisions recognize that certain constitutional freedoms are realized not merely through individual, but through collective institutions sustained by communities. Then, I have extracted Nagaraj, constitutional claim of individual right under Article 16.1 and the preferential treatment given to a backward class has to be balanced. Both the claims have a particular object to be achieved. This question is of optimization of this conflicting claim, conflicting interests and claims. According to me, I will skip this para 63, 64, go to para 65. Constitutional inquiry, therefore, cannot proceed on the assumption that individual rights must invariably prevail over collective religious rights. Constitution instead contemplates a structured balance between individual freedom and denominational autonomy, within which the autonomy of religious communities in matters internal to religion occupies a constitutionally protected domain. To approach the issue solely through the prism of individual rights would risk disregarding the institutional dimension of religion that the Constitution itself expressly protects. Then I come to whether Article 25 is a horizontal right. My lords have had occasion to deal with it in the Kaushal Kishore judgment, and my Lord Justice Nagaratna in the morning referred to this. Specifically, while making a chart and listing various rights, Article 25 is not treated as a right which can be exercised horizontally. It is a right which can be exercised. Therefore, the claim against the state can lie, but not against fellow citizens. 14, etc., stands on a different footing, but 25 is not. Therefore, an individual saying that I can exercise the right against other individuals who have another kind of belief, that kind of a horizontal right is not available. That's a view. My lords have analyzed all the fundamental rights in Kaushal Kishore and will take the view that this is not such a right. And what is horizontal and vertical, my lords know. I am not going to read that part of it, and then I'll go straight away to para 67.
Except in the case of habeas corpus.
I'm sorry?
Habeas corpus.
Yes, habeas. That's right.
That has been excluded by me.
That's right.
But
Article 20.
30.
Yes.
30.
Yeah, 30 also. Article 25 protects the individual's freedom of conscience and the right to freely profess, practice, and propagate religion against state interference, subject to public order, morality, health, and other provisions of Part 3. It does not convert disputes between private religious adherents, denominations, or groups into constitutional claims enforceable inter se. This is very important because in the morning there was a debate in regard to this. If there is a schism in the church, I have had occasion to deal with it in the context of Jacobites and Orthodox Christians. And there has been a schism running for 200 years. And as to which of them is right in terms of religious beliefs and faith is not a matter for the court. because we don't have a ecclesiastical court, we don't have a court with expertise in theology. That's not the what the constitutional courts are expected to decide. Both may be right. Both are entitled to their system of faith and belief. Therefore, both pursue their independent. They have their independent churches. They have the right to practice and profess their religion, their faith. Nobody stops them from doing that. But you can't say that you have to. That's what Portuguese sought to do. My lords, in Kerala, there's a famous Coonan cross. When the Portuguese came into Kerala, they sought to convert all the Syrian Orthodox believers into Catholics. There was a huge resistance. People therefore held on to a chain. And they said, you do what you want, but we are not going to convert ourselves and become Catholics. That's in Ireland, when the British Crown was ruling, the Catholics, they were subjected to differential treatment. They were said, you will not have right to property. The Protestants went to the extent of saying that the Anglican Church was controlling, and the Catholics were told, you will not have the right to property. You will not have the right to succession in regard to property. This was the kind of thing that was therefore forcing them to convert. But that, of course, that's why we still have the lingering dispute between Catholics and Protestants in Ireland even today. Therefore, this is not something which the courts will enter into, courts will not decide. Each is entitled to practice and profess their own beliefs.
That's why freedom of conscience.
That's a freedom of conscience. That's a freedom of conscience. Now, let I come to issue number 3. Whether the rights of religious denomination under Article 26 of the Constitution are subject to provisions of Part 3. My respectful submission on this is that 25 and 26, my Lord asked whether it reforms, it's a separate island. My respectful submission is it is a distinct constitutional framework. 26 is to be dealt with separately, Millard. 26 is not subjected to other provisions of the part, nor is 25(2)(b enabling the right under 26 to be controlled. 25(2)(b is only enabling a law to be made which can regulate the right under Article 25, the individual right. Therefore, if there is no prohibition in regard to making any law for social reform. Like, for example, if somebody says that there should be a uniform civil code, it is something which can be made under Article 25(2)(a). It can be the 25(2)(a) or the first part of 25(2)(b). First part, there are 2 parts to 25(2)(b). The second is in regard to entry. 25(2)(b) first part is in regard to social welfare reform, not religious reform. And therefore, the Hindu code was brought in like that. When we had, otherwise, prior to the Hindu code coming in, even amongst Hindus, there were persons who had 3 wives, 4 wives.
No, there was no restriction.
No restriction. There was no restriction. Bigamy came to be prohibited thereafter. Therefore, we have to keep all this in mind when we. Therefore, today, if in some other religious context, if this has to be regulated, perhaps 25(2)(b) first part can be invoked. It's for the legislature to decide. It's not for the court. It's for the legislature to come up with a law in regard to that. My respectful submission is 25(2)(b) is expressly creates a kind of an exclusion only in regard to the individual rights under 25 and not in regard to the denominational right under 25 too. Now, my lord, I'm
just here, when you say that 26 comes into play in relation to individual rights of 25, doesn't 25 in that respect get a horizontal projection? Because 26 is not a state right. It is a denomination right. And when a denomination right versus an individual right of conscience comes into clash, conflict, will not 25 be understood or 26 be understood as horizontal?
No, with the greatest respect, such an individual can continue to profess his own individual faith and belief. But he can't say that the religious denomination must follow mine.
Propagation.
Yes.
The word is not only practice, profess, but propagate.
Yes.
And that is where the individual's right of conscience propagation becomes eclipsed by the essential or the religious affairs managed by the denomination.
But he can't force himself.
Into conflict, will it not be a conflict of resolution of two fundamental rights and thereby making horizontal intrusions into each other?
An individual's fundamental right to profess, practice, and propagate religion does not mean he can forcefully assert his right.
Never saying it means that, but we mean when a conflict comes, that my degree, because everything is a matter of degree, sir.
Yes.
Not in absolute terms when we come to see two rights. And when I say my right to propagate will be eclipsed by a religious affair managed by a denomination, then I have a right to challenge the religious affair.
Yes, you can.
That challenge becomes a conflict between two fundamental rights on a horizontal domain.
The question arose before my lords in the context of conversion in Reverend Stanislaus. The court took the view there can't be any forced conversion. You can propagate, you can try to persuade, nobody can stop you.
Absolutely right. That is normative. But litigation is not normative.
No, litigation
is always
with the greatest respect.
Someone says this is forced, someone says no, this is voluntary.
Therefore, then, that is why, my lords took the view that this is not a horizontal right. Therefore, an individual cannot assert this right against either another individual or a collectivity. Therefore, this is not such a horizontal right which can be enforced.
This is more on a hypothesis.
Not under 32, not under 226.
We'll put it to you differently. 25 and 26 are same in certain way because rights are restricted with respect to public order, morality, public truth.
Correct.
So, if you, as you understand 26, 25 too.
That's a commonality.
Being enabling profession.
Yes.
It can confine at best. Let us forget about 26.
Yes.
At best only to public order, morality, and health.
Yes.
So, to that extent, you cannot say because 26 also says.
Correct.
If supposing let us say a particular religious denomination, its action is contrary to public order, morality, then
it can be enforced.
Then to that extent, you can trace it under section 25.
Yes. Correct. Correct. That
if you put it that way, probably the
yes, that I agree. What my lords have said, I can't possibly.
The three exceptions of 25(1)
yes,
will apply to 26 also for
yes.
the simple reason because the same expressions have been repeated there in 26
correct.
also.
I'm grateful.
But you are right in saying that 25(2) enabling provision is not applicable to 26 because sub-article 2 starts nothing in this article, article.
Exactly.
Constitution maker would have said nothing in this chapter or nothing in provisions and so will apply. Or they could say nothing in this in 26 subject to A, B, C, they could say and subject to 25(2).
Yes, could have said. But that's why very interestingly, 26B talks of manage its own affairs in matters of religion. 26D.
One other response to Bhagchi. 25(1)A is subject to other provisions of this part, which includes 26. That is why denomination overrides individual right. Because it's subject to other provisions. And which means that there is an unlimited. That's
There are two other submissions on this. 25 right is subject to other provisions of the Constitution, of this chapter, which means also subject to Article 26, number one. And my lords have rightly pointed out 25(2), the opening clause, nothing in this article shall affect. Therefore, only to this extent of 25(1), not in regard to 26. Then thirdly, 26D talks of administer such property in accordance with law. Whereas 26B doesn't say to manage its own affairs in matters of religions in accordance with law. Kindly see, very, very thoughtful Parliament in its wisdom, the Constitution, the makers in their wisdom have deliberately used different languages in regard to each one of these. And we have to give meaning and effect to each one of these.
Mr. Vaidyanathan, exactly this, what you are saying,
Yes.
subject to other provisions of this part, includes 26. Now, 26 is a right of the state or right of the collective individual, a collection of individuals.
No, 26 is the right of the denomination.
Is it the state?
I'm sorry,
It's
no.
definitely not the state.
No.
So, there is a horizontal intrusion of 26 into the right of the individual in 25?
No,
No.
the right of the denomination
Correct.
will prevail.
This is exactly what it's saying.
Correct.
A horizontal intrusion by a non-state
Correct. Yes.
into 25.
Yes.
And that therefore creates an interface between the religious denomination's fundamental right to manage its religious affairs vis-a-vis the individual's fundamental freedom of conscience and professing, practicing, etc. So this interface, can it be defined as a vertical expression of these two fundamental rights or an asymmetric?
I would respectfully submit these are two different verticals. We have to
But these
treat.
two verticals overlap.
No, therefore, in this, to the extent where 25(1) right seeks to assert itself against 26 vertical, 25(1) cannot prevail. But really speaking, such a conflict will not arise because
Let us say
25(1) right can be exercised by any person as an individual without becoming a member of that religious denomination. Therefore, there is no need for a conflict. The conflict will arise only if you say, I will have this belief and yet I will belong to that. That is the only situation.
this is the mirror image of the example that you gave. A 26B denomination comes to court seeking an injunction against an individual who is invading his religious affairs rights.
I will exercise my right on my own, either in regard to bar. That question, in fact, will arise. For example, in the case of excommunication. In the case of excommunication, that question will, because the Saidna is seeking to assert that right and say that you don't follow my tenets and beliefs, you are not following, therefore you no longer continue to belong to this group. Therefore, I keep you out of it. That is a right to excommunication. That is what is sought. Therefore, he goes to the court. When he goes to court, as my Lord Justice Sundaresh said, the test will be, is the excommunication contrary to public order, morality, or health. That's a test that will be applied, not whether power to excommunicate is part of essential religious practice, right, etc. That is not something that can be gone into.
Let us not overlap the two distinctions. The 25 talks of religious practice, 26 talks of religious affairs. That affairs is the management of it's a very broader and wide concept.
Very
It
well.
has nothing to do with practice.
Very well.
Therefore, what will apply to 25 will necessarily not apply to.
Very
But
well.
suppose for the law is enacted under 25(2), and that law, even if it affects religious practice, it might have some impact or effect even on 26 affairs. But that law will be confined only with reference to the power given under 25(2).
That's right. That's right.
It all depends upon provisions of a law. Let's not discuss
I'm grateful. Yes.
As well as Chair Reddy,
So to see what is actually being curbed in the garb of 25(2) vis-a-vis 26(b). You have to see actually what.
In regard to public order, etc., then the law will be upheld, but not when it comes to.
that's what we tell you.
Yes.
a law.
Please tell us, who is a religious denomination? Can I'll rephrase the question. Can the particular religious denomination, is it a person or not? Tell us, is it a person or not? Please answer. Is a religious denomination a person or not? If it is a person, it will come under 25. Then you tell us that how do you say that 25 will not be applicable? It says all persons are equally entitled. You can do it subject to the riders there. To say that a religious denomination will not come under the purview of a legislation or even executive action where social welfare and reform and under subsection 2B is too difficult for us to accept it. And notwithstanding this also, as per the submission made by AG and AG.
In the context of the fundamental right which has been given, which can be asserted under Article 32, which can be enforced under Article 32, every religious denomination
said both on a different thing. One is with respect to freedom to conscience and profess. Other is only with respect to managing religious affairs. And these are the characters. You can establish it, run it, administrate it, manage it, acquire the property. These are things. To that extent, there should not be very limited interference. What extent? You can't mix it up with the other one.
A law enacted as a part of a social welfare scheme, which is impacting the religious practice of an individual under 25(1).
Yes.
Can also have an impact on 26, because that very group of individuals is what referable to 26.
Correct.
But it will all depend upon, this question can't be answered academically on hypothetical basis.
Yes. Hypothetical
circumstance, it may impact 26, it may not impact.
Yes, correct.
It will all depend upon to what extent the legislature try to.
Whether it goes beyond public order, morality and health, or only in regard to dealing with public order, morality, and therefore that's a pith and substance of the law will have to be examined, whether it goes beyond that.
That's why my brother says that it may be difficult to accept it as an abstract statement that 26 will never be impacted.
If such a law is made and if somebody is aggrieved, both an individual and the religious denomination can challenge it, because the right under Article 26 is given to the religious denomination or section thereof. Therefore, that religious denomination can also assert that right under Article 32. That's a...
That's right. But you know, that as a juristic person, they can always.
Correct. That's right. That's right. Now, I come back to the submission, page 27, paragraph... in subheading B, when subject to other provisions of this part, I am dealing with that. And para 11, first limb, public order, morality and health, constitute direct constitute. Second limb is other provisions of the part. I want to emphasize one more in paragraph 12, I have set it. That kindly similar in 25(1), it talks of subject to public order, morality, and health, and to other provisions. Now, Millard, it is not subject to public order, morality, health, and to other provisions. This is a grouping. Public order, morality, and health has been grouped as one compendious expression or a justum generis, therefore, a common group. And then second is another and to other provisions. Therefore, public order, morality, and health will have to be understood as one compendious group. And Millard, that it is for that purpose.
Understood that.
Yes, yes. Then Millard, see.
Would you mean that one compendious group doesn't mean all three have to be there? Only one
No,
has to be there.
Millard, meaning.
Doesn't mean that everything should be there. All three should not be there.
Yes, that's right. My lords are right.
So then you can say, might argue that 20, then other provisions of the part means 26 is protected.
That's what we said.
Yes,
Not 25.
that's our submission. That's our submission.
26 doesn't have the right.
26
Other
doesn't have that.
provisions of this part.
Millard, in 26, they wanted to bring that, but it was not accepted. And Millard, 26 constitutional
But
history
under
will show.
26, it doesn't say other parts of part.
No, it doesn't.
So you will have to actually balance the whole thing.
Yeah.
And between the two is 25 2B.
Millard, 26, 25(2)(b), 25(2) is a power given to the state to make a law. It is not a fundamental right which has been given. 26 is the one that gives a fundamental right.
Has clearly said, see, they are travel and the scope is also different.
Yes.
Different, 26 different. There could be only one person.
Correct. Millard, I'll.
That's enough.
Yes, Millard. Millard, I have said express constitutional limitations cannot be expanded by implication. And in my respectful submission, Millard, the constitutional architecture of Part 3 is in such a manner that Millard, Articles 17, 23, and 24 form a separate group. Millard, this is a kind of not merely a right and a punishable kind of a thing. Article 17 prohibits untouchability, 23, 24, Millard, which expressly, Millard, in regard to prohibiting trafficking, forced labor, child labor, etc. Millard, therefore, this is a very, Millard, unique kind of a constitutional architecture where, Millard, by the Constitution, you have
17, I think we have understood, 17 is a very powerful constitutional declaration.
Yes.
As an offense. So it's not only an offense under the penal law, in a way it's a constitutional offense.
That's right.
If you are there to.
17, 23, 24, Millard, constitute one set of provisions, and Millard, 17, as my learned friend said, it is an atonement for our past. Whatever, Millard, historically, whatever injustice has taken place, it is an atonement for our past. Now, Millard, they constitute one category. Then we come to, Millard, Article 14, 15, 16, etc., where the enumerated anti-discrimination clauses. Then thirdly, we have 25 to 28, which in my respectful submission is a different set of where religious liberty and institutional autonomy is guaranteed. They stand on a slightly different footing. And what I have done, Millard, for at page 206, Millard, I have analyzed this part. Page 206
Yes.
to 214 in a chart. Millard, I have analyzed the various provisions of the Constitution, the various phraseology which has been used. Millard, I don't want to take too much time on this, Millard, but I have set out all that. And Millard, wherever they wanted to mention any provision in regard to non-discrimination on the ground of gender, sex that has been set out, and this is not is one of the submissions which I have already made. Now, Millard, I then go over.
You can categorize it. The first category is with regard to justice. The second category is equality. And the third category is liberty. They're all preambular rights which are
Correct.
actually adumbrated as
That's right.
constitutional guarantees.
That's right. That's,
Justice, equality, liberty.
that's right. That's right. I'll skip the rest of it, in order to keep myself within the time limit as much as possible. I'll go straight away to paragraph 48 at internal page 34.
Page 2.
Paragraph 48 at internal page 34. 203. 203.
203.
203.
Yes.
As regards Article 15(2), it does not include temples or places of public worship within its ambit. Constituent Assembly debates reflect that the proposal to include temples and places of worship in Article 15 was categorically negative. In paragraph 64-65, we have set out. Article 15(2) also cannot be precedent to service for asserting a right against essential practices. Then 29(2). No citizen shall be denied admission to educational institution maintained. Even this does not mention about gender. I have already pointed this out. Then 16.5. This is very important. 16.5. I'm in the context of analyzing the constitutional provisions on fundamental rights. 16.5 is very important, which protects law being made for that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. This has been noticed. Yesterday it was pointed out in Adi Saiva, but not in the other earlier judgments. And it becomes important because in Seshamal, if this had been noticed, perhaps that decision would not have been laid out. Aditya also. In Seshamal and Aditya,
Please repeat.
I'm sorry?
Please repeat. Please.
Seshamal and Aditya, which were concerned. Adi Saiva notices this. Justice Gogai notices this Article 16.5 and says that, but this has not been noticed in the earlier judgment.
Yesterday it was read out.
Yes. Now,
That appointment of secular activity.
That's right. Therefore, appointment of a person to an office by a religious denomination is treated differently in the very article dealing with equality in the matter of appointments, etc. Article 16 is in the context of equality of opportunity in matters of public employment. In that context, in Article 16(5), when it says, in regard to an incumbent of office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. Now, therefore, this is not treated as a secular office. It is treated differently. And if this had been noticed, perhaps the holding in Seshamal and Aditya that as if it is a secular appointment of an archaka, appointment of a pujari, appointment of a religious head of a mutt, is in the nature of a secular appointment, would not have been found. Therefore, one of the submission is this will have to be overruled. Now,
Article 16.5 could have found a place along with either 25 or 26.
Could have, yes, yes. This is therefore an exception which has been carved out in Article 16 in respect of a religious office. Yes. Now, I'll skip these and then I'll go to the fourth issue on morality, which has been considerably argued. Therefore, I am not going to take too much time on that. Page 40, internal page 48.
217.
217.
Yeah.
Yes. And the Hindi definition has also been given, but what has not perhaps been shown that it has to be read registrum generis with public order health. All these submissions have already been made. It can't be equated to constitutional morality. What has not perhaps been pointed out, there is one, the definition which has been pointed out on Sadachar. Yes. 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 I will only mention it. Sadachar has been pointed out. The word used, I just want to add this to the submission which has already been made. If they had intended the kind of meaning that is sought to be given, constitutional morality, then it should have expressed, it should have been expressed as Samvaidanik Naitikta. That is not the expression used. It is, therefore, we have to give a meaning to Sadachar, to morality, different from constitutional morality.
I understood your point. The literal translation would have been Samvaidanik Naitikta.
Yes.
Instead of that, the expression used in the Hindi official version is Sadachar.
Sir, let's
You understand?
Yes. Then I will go, I'll skip the rest of it. I'll go to paragraph 14 at page 55. That's page 224. 224. Why I am pointing this out is, in the earliest years, before this expression of constitutional morality was sought to be urged, what was being urged was the spirit of the Constitution. Therefore, in Keshav Menon in 1951, in the earlier years, the argument that was advanced before the court was that we have to understand the spirit of the Constitution, and if a law is contrary to the spirit of the Constitution, it will have to be held to be bad. And my lords held at paragraph 14, Keshav Menon, I am just reading that part of it. And page 224.
220, it starts, the citation starts.
Yes.
And you are reading at page
224, Miller. 220 is Navtej Johar. Yes. NCT of Delhi, Navtej Johar. I am not going into all that. It has been dealt with yesterday. Yes, Keshav Menon. In 1951, an argument founded on what is claimed to be the spirit of the Constitution is always attractive, for it has a powerful appeal to sentiment and emotion. But a court of law has to gather the spirit of the Constitution from the language of the Constitution. What one may believe or think to be the spirit of the Constitution cannot prevail if the language of the Constitution does not support the view. Then, I'll go to the internal paragraph 11. We are therefore unable to accept the contention about the spirit of the Constitution as invoked by the Learned Counsel in aid of his plea that pending proceedings under law, which has become void, cannot be proceeded with, etc. Then they say this Article 13(1), it has to be according to established rules of interpretation. It can't uninfluenced by an assumed spirit of the Constitution. Then Ambedkar, and that is dealt with by this honorable court in State of Bihar versus Kameshwar Singh. This is dealing with actually with the arguments of Mr. Ambedkar as a counsel.
So according to you, constitutional morality cannot be used for an interpretation.
Yes. Yeah, not for interpretation of the provisions of the Constitution. We have to read the word, letter, and then interpret it, not constitutional morality. And what the court says in Kameshwar Singh, towards the underlying portion, in my opinion, be contrary to elementary canons of statutory construction to read by implication those very limitations into entry 36 of list 2 alone or in conjunction with entry 42 of list 3 of the 7th schedule ought to deduce them from the spirit of the Constitution and that too in respect of the very properties excluded, because the argument was that this kind of acquisition, estate, cannot be acquired. And that argument was rejected. Similar argument in Anwar Ali Sarkar also. Now, Millard, I just want to mention two other cases where, Millard, again, morality itself was pressed as a ground. Millard, when Bearabond's case, Bearabond's Act was challenged in Arkegar by the celebrated lawyer, Mr. Arkegar, as a party in person. And Millard, passionate arguments were made by him in regard to that. And Millard, this is what the court said in that case, in para 18, at page 58, that is at page 227. It was then contended that the act is unconstitutional as it offends against morality by according to dishonest assessees who have evaded payment of tax, immunities and exemptions which are denied to honest taxpayers. And Millard, this contention is rejected. Similar argument in regard to Millard, the privy purse, Millard, and then Raghunath Rao Ganpat Rao's case. And Millard, that argument is also. Yes, Justice A.C. Gupta accepted the argument in Bearabond case. That's right, Millard, but not the majority. Millard, I have given the instances where this was not accepted. I don't want to take more time on this. Then, Millard, I go to issue number 5. What is the scope and extent of judicial review with regard to, that's Millard at page 62, that is page 231. 231. 231. What is the scope and extent of judicial review with regard to religious practice as referred to in Article 25? And Millard, I will skip and go. Millard, the headings are there: constitutional framework and meaning of religion, etc. And Millard, essential religious practice. Millard, I respectfully submit on this issue in Shirur Mutt, the question was under 25(2)(a), and that was concerning whether it was in regard to secular aspects of management of a temple or an institution, and it was not concerned with testing whether any practice is essential to religion. Millard, there is a very, very important difference. And Millard, it's our respectful submission that the Dargah Committee, Saidna's case, and Tilkayat, Millard, have erroneously approached it and adopted a test of essential religious practice. Millard, without going into all these passages, I come straight away to internal paragraph 15 at page 237. 237, my submission on this. My submission on this. Millard, may I read 4 lines above that, paragraph 14 ends. This marked, that is Tilkayat, marked a shift from the position that essentiality is determined by the adherence to the view that the court may itself delineate what is essential to religion and what falls within the secular sphere. It is respectfully submitted that the observations in Dargah Committee and Tilkayat suggesting judicial scrutiny of the essentiality of religious practices do not constitute the ratio of those decisions. The questions before this Honorable Court in those cases concern the validity of statutory measures regulating the secular administration of religious institutions and not the determination of whether particular practices were essential to the religion. The conclusions reached were therefore directed at the permissibility of state regulation of secular aspects associated with religious institutions rather than upon any adjudication that the practices in question were irrational, superstitious, or otherwise unworthy of constitutional protection. Nevertheless, those observations mark a discernible shift from the earlier bench decision in Shirur Mutt and Ratilal, which emphasize the autonomy of religious denomination in matters of religion. Then, Millard, kindly come to the bottom of the page, paragraph 17. The jurisprudence that followed in the Dargah Committee and Tilkayat reflects a gradual departure from the original jurisdictional function of essential religious practice doctrine as articulated Shirur. The doctrine was initially conceived as a means to distinguish religious practices which fall within the protected domain of Article 25 and 26 from secular activities associated with religion. This is the submission which may legitimately be regulated by the state. Over time, however, the doctrine has been invoked in a manner that draws courts into determining whether a particular practice is essential to the religion rather than whether the practice is religious in character. This is a very, very vital difference. Whether it is religious in character or secular in character is a test for the purpose of determining whether a law can be made, but not whether that particular practice is essential to the religion. That is not a matter which can be considered by the courts. It's not a matter in falling within judicially manageable standards.
It is specifically absent in the provision.
Yes. That's something, it's not there.
Then we need not go into that.
Therefore, this shift risks drawing secular courts into the religious thicket, requiring them to undertake theological evaluation that lie beyond the institutional competence of constitutional adjudication. Therefore, my respectful submission that my lords will not therefore entertain such question as to whether this is essential to the religion. That is a matter for the religion themselves to decide, the person adherence to the religion to decide, not for the courts to decide. Now, Millard, protection of, therefore, my respectful submission is protection of sincerely held religious belief. And Millard, this is on paragraph 20 to 22 deal with this. I won't take more of my lord's time on this. Limits of judicial.
There is no need to go into this essential religious practice
at all. That does not arise.
Heard at all.
Yes, only question is when a law is made, is it dealing with the secular matters or is it dealing with?
See, a secular activity which is associated with a religious practice is different from a matter of religion.
That's right. Therefore, my lords are absolutely right. Therefore, 25(2)(a) contemplates regulating economic, financial, political, or other secular activity which may be associated with religious practice, not dealing with religious practice or affairs of religion or matters of religion. That's a respectful submission. That is the only limited extent my lords will check it. That was what was laid down in Shirur and Ratila. But unfortunately, that subsequently in Tilkayat and Dargah Committee, etc.
Only at the threshold of perfunctory analysis should be made whether it comes under secular or it is religious.
Yes, that's it. That's it. Yes, sir. Yes, Saifuddin also. Yes. I go to paragraph 35, page 243.
Very lengthy note.
The determination of whether a practice is essential to a religion lacks judicially manageable standards. Where no such standards exist, courts must exercise constitutional restraint. This principle has been recognized in several decisions of the court, etc. Then, Millard, I give the South African case in the context of, Millard, there, very interestingly, Millard, South Africa has a number of Tamilians. The girl going to a school wanted to have a nostal and have flowers in her head. The school's uniform rules prohibited this. Question which arose in the Supreme Court of South Africa was whether she can be prohibited from wearing this nose stud. That it is in that context. That's an individual's right to have this. You can't prohibit that was the holding of the court. Therefore, under Article 25, unless, of course, in our constitution, it is again contrary to public health, morality, etc. If that test is not applicable, then you can't restrict or regulate. It is in that context, and I have just mentioned that. Yes. And therefore, what it says is, this will become otherwise totally subjective. Whether it is central to her belief is a matter which will be very subjective. So that is not a matter which the court will investigate, will go into. That is the holding of the court. Now, jurisdiction limits on sastric prohibitions of on altering rituals, I have referred to that. And I have also said today, whatever might have been the situation when Tilkayat came and when individual disputes, etc., arose, today, after the Place of Public Worship Act, this question perhaps may not arise, because there is a prohibition in regard to change in the nature. Whatever was the position in 1947 is what has to continue. That's a holding in the, that's a law laid down in Place of Public Worship Act. I refer to that. Now, on the section of Hindus, that's issue number 6. I will not read anything except the last 2 paragraphs, page 84, page 253. I will only point out the Pandora's box, consequences of accepting gender as a section of Hindus. According to me, gender or sex is not a matter for the purpose of, does not come within the section of Hindus. And but if we have to accept a contrary position, then the consequences is what I said to is this honorable to affirm the proposition that gender-based groups, the women of menstruating, constitute a section for the purpose of Article 25B. The constitutional jurisprudential consequences would be devastating and irreversible. Every gender-specific religious practice becomes judicially reviewable. By this logic, every gender differentiation religious practice across every faith becomes constitutionally suspect. In Islam, the separation of men and women in mosque, restriction of prayer leadership, imamat to men, would be open to challenge on the ground that women constitute an excluded section. In Judaism, the mechitza, physical separation, Orthodox synagogues, and gender-specific bat mitzvah ceremonies would face litigation. In Christianity, the Roman Catholic and Eastern Orthodox position on all-male priesthood would be open to constitutional challenge. Now, the Anglican Church today is headed by a woman. They have changed. Anglican Church has changed, but not. First time in history, yes.
After 1,400 years. Anglican Church is now headed by a woman after 1,400 years.
Yes, 1,000. Exactly. In Hinduism, female-only worship temples at certain Shakti temples, where men are traditionally excluded, and male-only entry to inner sanctums at several Kerala temples would also be exposed to challenge. Yesterday, the solicitor had given some examples. I'm not going into all of it. This concludes my first note, but the specific questions which my lords have been raising in the context of 25(2)(b) and 26, I have dealt with in a separate note. And that is the most important question which has been raised by all my lords. I'll deal with that. Yeah, it's a separate, it's a paper book which has been given.
You were requesting 2-3 pages note. Your juniors have unnecessarily reproduced so many things, making it so bulky. Yes, let's come to the right.
Yes.
Direct point, Mr. Vedanath.
Yes. Now, in that the note, the religious freedoms are intrinsic part of right to life and liberty. That I am not reading that. and essential to safeguard the plurality and maintain the unity. I may read only one part from St. Xavier's College. Kindly come to internal page 3.
Yes.
Last 10-15 lines. Provisions of the Constitution were designed accordingly. There is no mysticism in the secular character of the state. Secularism is neither anti-God nor pro-God. It treats alike the devout, the agnostic, and the atheist. It eliminates God from the matters of the state and ensures that no one shall be discriminated against on the ground of religion. Constitution at the same time expressly guarantees freedom of conscience and the right to freely profess, practice, and propagate religion. Constitution makers were conscious of the deep attachment the vast masses of our country had towards religion, the sway it had on their minds, and the significant role it played in their lives. To allay all apprehensions of interference by the legislature and the executive in matters of religion, the rights mentioned in Articles 25 to 30 were made part of the fundamental rights, and religious freedom contained in those articles was guaranteed by the Constitution. To allay all apprehensions of interference by the legislature and the executive in matters of religion, these were made parts of fundamental rights. As in the case of religion, so in the case of language, I won't trouble my thoughts with that. Go straight away to the issue to be addressed, that is page 5. Constitutional relationship between 25(2)(b) and 26(b). 25(2)(b) is an enabling provision. The carve-out it creates is expressed in the words "nothing in this article," confined on a plain reading to Article 25 alone. The respectful submission is that it cannot, on its text, override the right of a religious denomination under Article 26 to manage its own affairs in matters of religion. Correctness of Venkatramana Devaru calls for consideration. In addition, the classification of Archaka appointment as a secular function in Seshama requires reconsideration in the light of Article 16.5 and the Agamic prescription governing such appointment. Then the rest I will skip. Yes. Yes, therefore I will skip that. I will now go to page 6, where Devaru, unfortunately, in the compilation, fourth compilation, these passages in Venkatramana Devaru have not been set out. Let me read that. It is not in the convenience compilation. We are given copies. We are given SCC copies. We are given the paragraph 28 in SCC.
27 half paragraphs.
Yes. SCR, unfortunately, has omitted a part of the text of the judgment.
27.
Yeah.
28, 27 half para and 28. Digital version. Maybe the original is there, but the digital version is omitted.
And what is there in the convenience of it?
The digital version has unfortunately omitted it. That's why it's not in the compilation.
So which paragraph you want to read, Mr.
Yes. Para 28, which is in my paragraph 4, page 6. And lastly, it is argued that whereas Article 25 deals with the rights of individuals, last paragraph, extract,
Page 6.
in page 6. Lastly, it is argued that whereas Article 25 deals with the rights of individuals,
Justice Kumar does not.
My Lord.
Justice Arvind Kumar.
Justice, my Lord, sir. And lastly, it is argued that whereas Article 25 deals with the rights of individuals, Article 26 protects the rights of denomination, and that as what the appellants claim is the right of the Gaudasaras or Brahmins to exclude those who do not belong to that denomination, that would remain unaffected by Article 25(2)(b). The contention ignores the true nature of the right conferred by Article 25(2)(b). That is a right conferred on all classes and sections of Hindus to enter into a public temple. and on the unqualified terms of that article. That right must be available whether it is sought to be exercised against an individual under Article 25(1) or against a denomination under Article 26(b). The fact is that though Article 25(1) deals with the rights of individuals, Article 25(2) is much wider in its content, and it has reference to the rights of communities and controls both Article 25(1) and Article 26(b). That no reasoning has been given. And significantly, Shirur Mutt and the subsequent judgments, 7-judge bench and 5-judge bench, have not been dealt with. Those have been relied upon. They expressly hold to the contrary. I have extracted those passages and I will deal with it. This is a bare assertion. There is no reasoning. And they have not dealt with the larger bench, 7-judge bench judgment, which says 26(b) is not controlled by this. The court did not explain how a provision saying nothing in this article can also mean nothing in Article 26. Therefore, adding words 25 and 26, self-limiting language of Article 25(2) was not confronted, and the conclusion that Article 25(2) controls Article 26(b) is unsupported by the text of the provision. The part of para 27, which is also not found in the compilation, it is undoubtedly true that the right conferred under Article 26(b) cannot be abridged by any legislation, but the validity, please see, mark this, right conferred under Article 26(b) cannot be abridged by any legislation, but the validity of Section 3 of Act 5 of 1947 does not depend on its own force, but on Article 25(2)(b). 25(2)(b) merely is an enabling provision to make a law. Therefore, how can that control 26(b)? That, unfortunately, the reasoning, there is something missing in this. The court thus accepted that no legislation can abridge Article 26(b) under the Madras Act tested on its own force violate Article 26(b). Act was saved only because the court held that 25(2)(b) itself can override 26(b). That, my respectful submission is incorrect. And I want to read what has been, please see the holding in Devaru Para 9. The court then stated, we must accordingly hold that the rights of appellants have to be determined solely with reference to Article 26(b). Then Section 3 of Act 5 should be held to be bad as infringing. This is a binding finding. This is what Devaru, in the earlier part, they say. This is a binding finding. The question of who may enter temple or worship when governed by agamic and theological prescription is a matter of religion within Article 26(b), and a law compelling entry violates that right. The only reason that law was upheld was the court's subsequent conclusion that 25(2)(b) overrides 26(b). Once that conclusion is shown to be textually untenable, findings at pages 241 and 242 is determinative. This finding by
Venkatramana Devaru, with regard to the Gauda Saraswat Brahmin temple, there was a suit which was filed.
Yes.
And it was established in the suit that all persons other than Gauda Saraswat Brahmins were excluded. When the matter was pending, the constitution came into force and Article 25 and 26 was pressed into service, and simply it was applied to the suit and contrary to the findings. And that is how the matter came up. When the matter came up before this court also, they took the same position that Article 25 and 26 is there, forgetting the fact that it has arisen from a suit and not a writ petition.
And significantly, factually, as my lord rightly pointed out, there was a declaration that it is a denominational temple. That came right up to this honorable court, and the court affirmed that it is a denominational temple. Now, in the very suit which came up finally and which was decided in Venkatramana Devaru, there was a finding by the trial court that it is a public temple, affirmed by the First Appellate Court that it is a public temple. Mr. Nambiar said that this is a matter on which I should be allowed to challenge this part of the finding, that it is not a public temple, it is a private temple. Because he said that it has already been declared to be denominational temple and that has been affirmed.
Not private, denominational.
Yes. Now the court said there is no pleading to that effect. You have not claimed it to be a private temple. You can't today be allowed to plead that it is a private temple. Now, therefore, there was a completely contrary situation. One declaration that it is a denominational temple, another declaration that it is a public temple. This was the factual situation, peculiar factual situation in Venkatramana Devaru. Now, they had to reconcile it both. One, the other one court said, I won't allow you to challenge because you can't be asked to, you can't be allowed to argue that it is a private temple, that it's not a
even if it's a public temple, there's no bearing on denomination.
As a denominational temple, it would have been open to them to give permissive right to enter and have worship, but or confine itself only to the denomination. If it was only a permissive right, and that was the argument of Mr. Nambiar, it doesn't become a public temple. It wouldn't have become a public temple. It is only in respect of public temple that 25(2)(b) law could have been made in regard to entry. This was the peculiar situation because of which, unfortunately, this Justice Venkatramaiah was faced with a peculiar situation while in this case. He had to, in my respectful submission, there were two judgments which were binding on the bench. One of a 7-judge bench, another of a 5-judge bench. And my lord, these could not have been got over. If my lords will go to internal page 12, where I have extracted, so that my lords don't have to go anywhere else, internal page 12, what Shirur Mutt said. And my lord, this can't be got over. And today that's a law. And my lord, I would respectfully appeal to my lords to uphold the Shirur Mutt provision, Shirur Mutt holding.
And without there being any law, State of Mysore only pressed upon Article 25(2)(b).
Yes. Yes.
In the absence of making any law to that effect. And that was...
There was a law. There was a law. That was under challenge. Yes, in the suit.
That came,
Yes, it came later. It came later.
Constitution came
Yes.
later after the suit was...
That's right. That's right. Well, Shirur Mutt, first, the extract. The extract, I'm reading only the extract. Administration of his property by a religious denomination has thus been placed on a different footing from the right to manage its own affairs in matters of religion. That is 26D compared to 26B. The latter is a fundamental right, that is 26B, which no legislature can take away, whereas the former, that is 26D, can be regulated by laws which the legislature can validly impose. This is what 7 judges said.
You are relying on this.
Yes, I'm relying on this. I respectfully submit this is the correct view. And Miller, unfortunately, this has not been dealt with or distinguished by Venkatramana Devaru. Then Miller, the next extract, under 26B, therefore, a religious denominational organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of the religion they hold, and no outside authority has any jurisdiction to interfere with their decision in such matters. This is again reiterated 2 days later in Ratilal. Kindly see, and my lords have seen 5 of the judges are common. Ratilal, extract is in next page. Yes. At page, in that extracted portion, underlined portion, language of the two clauses B and D of Article 26 would at once bring out the difference between the two. In regard to affairs in matters of religion, the right of management given to a religious body is a guaranteed fundamental right which no legislation can take away. On the other hand, as regards administration of property, which a religious denomination is entitled to own and acquire, it has undoubtedly the right to administer such property, but only in accordance with law. This means that the state can regulate the administration of trust properties by means of laws validly enacted. But here again, it should be remembered that under Article 26D, it is the religious denomination itself which has been given the right to administer its property in accordance with in accordance with any law which the state may validly impose. A law which takes away the right of administration altogether would amount to violation. Then, Miller, please see the next extract also. No outside authority has any right to say that these are not essential parts of religion. Now, Miller, please see the other series of judgments which say that court can examine whether it is essential part of religion. No outside authority has any right to say that these are not essential parts of religion. It is not open to the secular authority of the state, and state includes.
Continue, please.
And, yes. And it is not open to the secular authority of the state to restrict or prohibit them in any manner they like under the guise of administering the true estate. Now, my laws have taken the view, state in Article 13 includes the court. Therefore, even the court cannot go into whether it is essential part of religion or not, because state is prohibited from going. Secular authority of state is prohibited from going into whether it is an essential part of religion. This is the belief of the community, thus observe the learned judge, and then it's not the secular judge is bound to accept that belief. It is not for him to sit in judgment on that belief. He has no right to interfere with the conscience of a donor who makes a gift, etc. These observations, afford an indication of the measure of protection that is given by Article 26B. Unfortunately,
one apprehension. Keep this in mind, please. Keep aside the controversy in Sabarimala. If you say this right of entry in the context of Venkatramana Devaru, where they said anybody other than Gauda Sarvaswat Brahmin is excluded, it will affect negatively Hinduism. You see, everybody must have access. Keep aside the controversy in Sabarimala. Everybody must have access to every temple and mutt. Yes. But if you say it is a practice, it is my religion, it is a matter of religion, that I will exclude. Only my section, my denomination must attend my temple and none else. That is not good for Hinduism. Keep that in mind. Keep that in mind.
You will be dividing the society.
Yes.
Dividing the society.
I have.
Speaking of,
I understand. The pragmatic.
Venkatramana Devaru is, what is that, per incurium or whatever. It can be one thing distinguished.
Yes.
That is one thing. But let the religion not be adversely affected.
Realities, I respectfully submit. The reality, there are very few persons, there are private temples. There are ancient Tharwads in Kerala. Similarly, in other parts of the country also, which have their own small temples, goodies, where they don't allow.
Talking of goodies or small private temples, it is there.
Which they hold only. Similarly,
family goodie, we are not on.
Correct. One. Next.
Temple.
That is family. The second, denomination. Denominations also, if they want to have only for the denomination, they can't seek funds either from the state or from private donors or from public, because they will be depending, they are not dependent on footfall from others.
Be counterproductive to that denomination.
That is a matter for them to decide. Is it,
On the other hand, if there are more
Let-
people devoted.
the question is it contrary to the constitutional prohibition? That will be the question. My lords will have to consider.
See, please.
My lords will have to look at whether it is contrary to public order, morality and health. If it is not contrary to public order, morality and health, what the realistic consequences in terms,
Only asking in the context of entry, nothing else.
nobody,
Not any other religious aspect.
therefore,
Keep aside Sabarimala controversy.
yes.
Generally, if you say only persons of Gauda Saraswat only must come to this, followers of Kanchi Mutt only must go to Kanchi, followers of Kanchi Mutt should not go to Sringeri, followers of Sringeri Mutt should not, that is not
Ordinarily, that is the reality. That is why it may not happen.
See, the greater the people who go here and there, the strength therefore, when we argue, please respect.
I'm conscious.
When we are.
We are turning the clock, sir, if we accept this.
Access to temples. Access to temples.
I'm conscious of this. I will respectfully submit. This is a matter which will be taken note of by every denomination and then take decision. There can be small close.
State can step in under section Article 25(2)(b).
We are now testing as my lords rightly put it, we are now testing the provisions of the law based on the constitutional provision.
That is why we are telling you, don't pitch it so high.
Sir, we will be turning the clock.
I have to go by the text of the constitution.
So,
I am going by what my lords have taken, what my lords have said in Shirur Mutt, 7 judges. Today, the decision of a 7-judge bench in Shirur Mutt is that. Today, if my lords want to rewrite that, that's a different issue. I respect.
So, in the context of entry.
So their work is to argue.
May do this. I have.
Please think over.
We will need. This is a very, very crucial question. If my lords, I will need about 45 minutes for.
No, 45, we'll have to conclude, Mr. Vaidyanathan. It's already ended 20 minutes against 90. We will wait for another 5-10 minutes. Please wind up.
I'll do that.
Please, please.
If a law is to be made, it has to pass the test of whether it is public order, morality and health. Under 26.
Pass the muster of 25(2) also.
There I have a respectful submission. 25(2)(b), with the greatest respect.
We got it. We understand your argument.
Yes.
Yeah, 25(6) travels on his own channel.
Yes, 25. Well, that's a submission. What I have done, I'll quickly run through since my lords have understood. I don't want,
we don't want to extract a confession from you in the name of concession. You argument what you want to argue.
I am making a submission that Shirur Mutt is right. Shirur Mutt holds this. And Shirur Mutt has to, my lords in 9 judgments.
This argument you can have, because what 7 judge has held, the subsequent 5 judge appears to be in conflict, maybe partly, maybe to a larger extent. That's what we will try to resolve.
Yes. 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 Now, I have dealt with the factual freezing point, that is at internal page 10. And, therefore, they were. Yeah. The agamic understanding in regard to public temple, kindly see that part of it, Gopal Mopana, because this was the factual findings staring in the face of Venkatramana Devaru case, because the court had taken the view that it is a public temple. What is a public temple? Gopal Mopana definition is relied upon. Gopal Mopana says it is clear from para 20.
Which page?
Yes. 11. It is clear from the above. Page 11. Page 11, para 20.
Go back there.
Going back. Yes.
Yes. It is clear from the above that temples were intended for the worship of people belonging to all four castes without exception. Even outcasts were not wholly left out of the benefits of temple worship. Their mode of worship being, however, made subject to several restrictions. Then Millard, para 22, a Hindu institution of a public character, by its plain meaning, cannot be an institution of a religious denomination or section thereof. Very judgment in Devaru, that is Gopal Mopana, referred to in Devaru, Gopal Mopana, makes it clear that religious institutions of a public character are those which are intended to belong to all, including outcasts. In this regard, it is crucial to underscore that 25(2)(b) pertains to Hindu religious institutions, not religious institutions of Hindus or any section thereof. If Article 25(2)(b) was intended to cover religious institutions of subsects of Hindus, then the words had to include Hindus or any section. That's not so. Devaru's holding rested on the specific factual and doctrinal foundation. It does not extend to Sabarimala Temple, which is not a public temple in this agamic sense. It is a denominational temple governed by specific agamic prescriptions tied to the theological character of the deity. The basis for its practices is not public dedication with caste-based restriction, but specific denominational theology concerning the nature of the presiding deity. Devaru is not authority for the proposition that Article 25(2)(b) can override the denomination's practices rooted in the theology of the deity. Then, Millard, kindly come to page 14. Millard, if this construction is adopted, Hindu denominations will be uniquely disadvantaged because 25(2)(b) talks of a law only in regard to Hindu public temples, not in regard to places of worship of other religion. Therefore, Hindu temples will be uniquely disadvantaged by this interpretation by saying 25(2)(b) can affect even 26(b) right. Only Hindu religious denomination under 26(b) will be subjected to this legislation under 25(2)(b). No religious denomination of any other religion will be affected.
Because
Because
of the history.
The word social
history of the
reform will
Hindu
take care of
society.
There is no question of, there is no caste system there in other religion, Islam and.
restricted only to Hindus.
Then you know,
Social
Yes.
is sufficient to take care of the other.
Well,
That's
no constitution will not be read in a manner where any part of the text will be treated as surplusage. Well, if social reform can take care of it, there was no need to make a separate provisions. Second part of 25(2)(b).
You have already said that 25 has to be read with Article 17. Article 17.
Yeah.
So the over-eagerness of the constitution makers to make Article 17 more.
Any public temple will be subjected to Article 17. But if it is a denominational temple, which is not a public temple.
Mr. Vaidyanathan, let's not, this argument probably, for two reasons it will not survive.
Yes.
One, that what you are arguing is directly in the teeth of language of 25(2)(b, directly in the teeth of that. Assuming 25(2)(b will, as we were using the word, will have no impact on 26. 26 itself is guided by three principles.
Yes, that-
morality.
That of course I will.
Article 17 is a principle of morality.
If it is a law, if it is a law which passes the muster of those three, I'm out. Then I have nothing further to say. I'm bound by it, but not 25(2)(b) law.
one other way of looking at it is if you restrict it to that particular denomination,
Yeah.
it is contrary to morality under Article 26 itself.
That's a view that can be taken. That's a view that.
On any other affairs.
If that view is taken, then of course it's a different thing. Yes, that's a possible. That's a, Millet, now I come to, Millet, I just want to give,
Divided further, we have to unify.
yes, Millet, make quickly complete, Millet, so that, Millet, I'm just on, in the context of,
What is the argument you really want to develop at page 17?
yes,
By referring to.
that is Article 29 and 30, where there is no reference. Therefore, the law cannot be made compelling persons to admit persons belonging to a different sex if it is a institution exclusively for girls or boys. If that can be done, why should the 25(2)(b) doesn't talk of gender or sex? It talks of class.
Social welfare. Education is part of social welfare.
No. Therefore, that's an argument in regard to that. Then, at page 20, I have said about Seshamal and Adityan. I have already argued that. I won't repeat that. I won't repeat that. I only one more thing I want to mention, page 25, because this was one apprehension expressed yesterday by the learned solicitor. I have said it won't affect social welfare legislation or the power to enact a uniform civil code, etc., because 25(2) takes care of that. It can curtail individual rights, 25(1), and law relating to marriage, divorce, succession, uniform civil code, triple talaq, all these laws can be dealt with as a measure of social welfare or reform. They will not be affected in any manner by any such law. And
there's an inherent contradiction.
Yes.
You can't take the stand here and say triple talaq is okay because that is also part of religion.
That
you may not subscribe because there are ways how it has to be approached and how it has to be done. Yeah. If someone misuses or interprets that, it does not give a right for the court, for the state to interpret.
I am putting it on.
You can't have this contradictory stand.
No, my respectful submission is this. These are laws relating to individuals' rights. It is not a law relating to a religion or a religious denomination.
Marriage itself is part. Otherwise, you go get yourself married and the special marriage is
you
can't have this.
Matrimony, etc. is individual's right. That's a matter which may pass muster, is my submission.
You can't argue like this.
You
have to take responsibility for
that. That's a matter which can be considered. I have one last submission, two last submission. One is religious denominations' rights are not merely in regard to temples and institutions of that kind, but even in regard to educational institutions. That is the view that has been taken by my lords. In Siddharaj Bhai and subsequently in TMA Pai Foundation. In my note I have given, I may just hand it over. In TMA Pai and Inamdar, certain rights have been given to the institutions, educational institutions run by minorities. When we talk of, since my lords are considering the rights under 25 and 26, I would respectfully appeal to my lords to also go into this aspect of the rights of religious denomination in regard to educational institution, whether they should not have autonomy in regard to selection of students.
That may not come with, we are talking.
Your lordship.
Religion.
26, my lord, question 1 and 2 are in regard to the scope of the right. That right has been held to include right to have education. Your lordship may say that this is a matter which can be considered in another case. But if it is to be considered...
Hindu has been defined. Hindu has been defined. All those will come. Then you say, I am a denomination. You have to move out also and say, no, I give this protection.
No, I am respectfully submitting.
26B.
My respectful submission is...
In fact, it is absolutely not needed to be gone into.
No. That may not come really strictly.
Your lordship may decline. The question is widely worded, but my lords may say that I will not go into that.
We appreciate your contention.
Yes, correct. Because denomination should have the same right as minorities is the submission. Then one last thing. I have made a tabular statement of the earlier judgment. Some judgments may have to be overruled. some judgments may have to be clarified. I have given a tabular statement, setting out as to what, according to me, need to be dealt with. I believe such
Yes,
a
we have received
yes,
this.
yes,
Got it.
yes. This, my lords may consider.
Thank you, Mr. Vaidyanathan.
I am very grateful.
And this side is a very unpredictable class.